They had an emergency count here at the jail, so that was a little problem.
I understand. Hey, life happens. I'm not I'm not a person that gets hold on, Mr. Barbie, don't go anywhere. I'm not a person that's gonna get out of whack because something pops up.
I'm still here, Judge. I just need to grab something for like 10 seconds.
Okay, go ahead, sir. Okay. So, Mr. Barbie, we're going to deal with you first since your client is not present and you've agreed to waive his presence. Is that correct, sir?
That's correct, Judge. We are waiving Mr. Arnold's presence. So Leonard Arnold.
Okay.
There's 2 warrants for the court.
Yes, sir. He's charged in warrant number 2020 CW 50278 with battery. That's a misdemeanor. He's charged in warrant 2020 CW 50279 with robbery, and that's a felony. So he's going to have a $5,000 bond for each count. So it's going to be a total bond of $10,000. He is going to have a preliminary hearing date set for December 1st at 8:30 in the morning. Courtroom 201. That date will get waived upon his bonding out, and he'll receive a new court date in the mail. There's going to be a stay away provision on his bond for him to stay away from a robbing Price.
Now, that's going to be a complete stay away or just no violent contact?
It's going to be a complete stay away. He has a lot in his criminal history. And the allegations here, it appeared to what I thought it would be, like, snatching the phone out of girlfriend's hand or whatever. So it's not something that is the robbery count. It's not something that's the end of the world. But what we do in these cases is that we place a stay away provision on the bond. And if he wants that to be removed, the victim will have to contact the DA's office. And they have their investigators and they'll look into it. Because this is a situation where it's pretty much one-sided. Like, I don't know Miss Price, never met Miss Price. I don't know what her desires are. Instead of figuring out her desires when he comes back home and she doesn't want him to be there and the police are called and he's arrested again or whatever, we place a stay away provision on that so that it can be taken off. If they're fine, they're cool, this was just an isolated incident. So unless and until we get to the point where we have both the solicitor's office and the police officers and everybody appearing at first appearance so I can ask questions, we'll just place a stay away provision on with the understanding that it can be taken away.
Okay. Thank you, Judge. I will convey that to my client.
Now, this is the one thing, because Mr. Arnold is in Cobb County right now, and based upon the conversation that I had with you, he's in a position where he can be released. He's not going to be released on this bond until he's been fingerprinted on these charges. So hopefully this will start the start him down the road where Cobb County will see that there is a bond in place for him, and that they will send him here, or they'll contact the sheriff's department so that someone can go pick him up. They'll release him. We can go pick him up, bring him here. He can be fingerprinted on these charges, and then he can bond out. Okay. And I know it adds an extra level to this, but you know, Mr. Arnold has sort of played a part in this being complicated. Okay. All right, sir. Is there anything else, Mr. Barbie?
Not this time, Judge. That concludes my business with the court.
Okay. Thank you, sir. You're free to go.
Thank you.
Okay. Let's get started. All right. So we're going to have to continue Mr. Lester. I understand that.
It's a female, Your Honor.
Oh, Miss Lester. Oh, wait a minute. She was the person that got continued from yesterday, correct?
That I don't know.
Hold on one second, because I saw there was a person. Yep, Rashida Lester. She got continued yesterday.
Really? Okay.
Yeah, because she was doing the same thing. What I'm going to do is this. I dismissed the WAA for the aggravated assault, but I set bond on simple battery and obstructing an officer. And I'm going at $5,000 each, and I'm going to present those orders. She's not going to be holding the whole system up by her behavior. So she's going to have a bond.
I believe she's, I'm sorry, I apologize.
No, go ahead.
I believe she's demented, Your Honor. I can tell just a little bit. So
right.
That's playing a factor or not.
Well, and so the thing is, like, I don't have anywhere to put her.
Right.
So she can sit in the jail forever if we don't at least set her a bond.
Correct.
And try to move her case forward. I'm going to appoint a lawyer to represent her. I'm going to place on the CAA form that she has potential mental health issues. And I'm going to trust that lawyer to represent her.
Okay.
So that she's just not just hanging out here in no man's land.
Yes, sir. I'll let the jail side know so they'll know what to do with her next.
Okay. All right. Thank you.
Yes, sir.
Okay. Good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner. I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance. I did, Marie, whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies, or by accusation for misdemeanors, to have a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. Purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Lastly, I need everyone to raise your right hand, please. Do you swear or affirm any statements you make during this proceeding will be the truth, the whole truth, so help you God? Okay, let's start on the ladies' side with Miss Grissom.
Doing the ladies first. When you look up here, you can see what goes on.
Are you Miss Grissom?
Yes, sir.
Ma'am, you're charged with one count of violating Georgia Controlled Substance Act, possession, simple possession. I've set the bond at $3,000. One count of use or possession of a drug-related object. I've set the bond at $1,500. And one count of driving a vehicle without a valid license. The bond is going to be set at $1,000. So you're going to have a total bond set at $5,500. You believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for December 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You currently working, ma'am?
Yes, sir.
About how much do you make per hour?
$12.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay. Ma'am, you're free to go back.
Thank you.
Mr. Ryan. Ryan, is it Reen or Ryan? Oh, he's frozen. We've had a lawyer come on, but I think his feed is frozen. So with Miss Lester, I'm going to go ahead and deny the WAA on the aggravated assault charge. I'm going to set a bond at $5,000 a piece on a simple battery and instructing an officer. So that's going to be a total bond of $10,000. And as I stated before, I'm going to appoint a lawyer to represent her. And I'm going to place on her CAA the fact that she may have a mental health issue. Okay.
Okay.
All right. So the lawyer, Mr. Ryan, is it Ryan?
Yes, Your Honor.
Who are you representing here today, sir?
Brett Lawler, Your Honor.
Brett Lawler. Okay. Let's pause for a second. Let's bring Mr. Lawler up on the ladies' side. I'm sorry, men's side. And that's Lollar, correct?
Yes, Your Honor.
All right. So he's charged with one count. Mr. Lawler, you've taken advantage of the opportunity to hire a lawyer. So I'm going to speak to your lawyer here instead of speaking to you. But I have to caution you that this proceeding is not privileged or private. So anything you state will be heard by everyone. So please don't say anything that you would not want the whole world to know. Okay, sir? So he's charged with one count of theft by taking as a felony and one count of conspiracy to commit a crime. I've set bond on these offenses at $10,000 each. But I'll hear from you, counsel, as it relates to your client and the bond and this offense.
Thank you, Your Honor. There was already a civil suit about this case, which was resolved. I was part of the resolution of that. I was surprised the criminal charges were filed. I just asked for a recognizance bond, if possible, Your Honor. There's no Mr. Lawler is not a flight risk of any sort. He resides here in the Atlanta area with his wife. He's been in communication with me. We were just shocked that he was picked up by the cops. It was not necessary. We just asked him to be let out on a recognizance bond and give me a chance to work with him on the case.
So the way that the unsecured judicial release bonds work, now I have to speak to my chief about this, which means he would have to stay in jail another day for me to be able to speak to her about this and for her to come up with an answer as to whether she's willing to grant this or not. This did appear to be potentially punitive to me as I've read through the warrant, and I saw that these charges grew out of a civil deposition, I believe, or a civil case. And
yes, Your Honor, there was actually a default judgment entered against my client as part of a sanctions in a civil case. It does appear to us to be punitive. And what I would suggest is I prefer that he not need to spend the day in jail while we wait on a recognizance bond. Perhaps if bond could be set at a very low cash bond, just as low as you can go without getting special permission of the chief.
I'll tell you what, I'll reduce it to $2,500 for each count. That'll be a total bond of $5,000.
Thank you, Your Honor.
And he can make this bond by cash, commercial, or property, which means he can go through a bonding company. He can post the entire amount in cash. Sheriff will return that amount when the case is over, or he can use, if he has property that has at least 3 times equity, which will be about $15,000. He can use property to post his bond. The sheriff's department will place a lien on the property, and when the case is over, they'll remove the lien.
Thank you, Your Honor.
Okay. He's going to have a preliminary hearing date that's set as a placeholder date for December 1st at 8:30 in the morning, courtroom 201. Once he bonds out, that date will get waived and he'll get a new court date when the case is assigned to a judge in Superior Court.
Thank you, Judge.
No problem. Is there anything else, sir?
Nothing from me, Your Honor.
Okay, you're free to go. Mr. Lawler, you're free to go back, sir.
Thank you, Judge.
You're welcome. Have a good day. Okay, Miss McCoy.
Yes, Your Honor.
Good morning, ma'am. You're charging one count of disorderly conduct. Bond is going to be set at $1,500. Can you make that bond?
I will try my hardest, sir. I'm unemployed at this moment.
Okay. There's going to be a preliminary hearing date set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, ma'am, you said you're unemployed?
Yes, Your Honor.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, Your Honor.
Okay, ma'am. You are free to go back.
All right, thank you.
You're welcome. You too. I still didn't get the CAA forms yet. Miss Morales.
Okay, so I'll check into it for you, sir.
Okay. Ma'am, you're charged with one count of possession of marijuana less than an ounce. Bond is going to be set at $1,500. One count of use or possession of drug-related objects. Bond is going to be set at $1,500. And one count of an improper turn, meaning not using your signal light. Bond is going to be set at $500. So that's going to be a total bond of $3,500. Do you believe you can post that bond?
Yes.
Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see you if you qualify, ma'am, for the appointment of a lawyer?
Yes, please.
Are you currently working, ma'am?
Yes.
About how much do you make per hour?
About 15.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, ma'am, you're free to go back. Miss Percy. What are you doing? Ma'am, you're charged with one count of theft by receiving stolen property as a felony. And bond is going to be set at $5,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for December 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
Yes, sir.
About how much you make per hour?
$12.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, ma'am. You're free to go back.
Thank you.
That's it for the females, Your Honor.
Okay, thank you for your assistance. Have a good day.
So I'm gonna check into those CAA forms for you.
Okay.
All right.
It says I just received an email that they have, let's see, chat. It says they have been mailed.
Okay.
So it looks like they were just emailed at 11:22.
Okay.
Okay.
All right.
All right. Thank you. All right. Let's switch over to the mail side. Mr. Abdul.
Yes.
Good afternoon. Good morning, sir. You're charged with one count of driving a vehicle without a valid license. Bond is going to be set at $1,000 for that. One count of reckless driving. Bond is going to be set at $1,500. One count of looks like speeding. Bond is going to be set at $1,500. One count of giving a false name, address, or date of birth. Bond is going to be set at $2,000. One count of possession of weapon during the commission of a crime. Bond is going to be set at $5,000. One count of possession of a firearm by a convicted felon. Bond is going to be set at $5,000. And one count of simple possession. Bond is going to be set at $3,000. So you're going to have a total bond of, 10, 15, 18, $19,000. Do you believe you can post that bond?
Yeah.
Your preliminary hearing date is going to be set for December 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
No.
Okay. You're going to hire your own lawyer?
Yes, sir.
Okay. Do you have any questions for me?
No, sir.
All right, sir. You're free to go back. Mr. Adams.
Yes, sir.
Sir, you're charging one count of simple battery. Bond is going to be set at $4,000. You believe you can post that bond?
I wanted to ask if I could be released on my requirements due to my medical conditions. I have some severe medical conditions.
Okay, we'll come back to that. There's going to be a stay away provision on the bond to stay away from Marvin Morris. Do you understand that?
Yes.
There's going to be a preliminary hearing date set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No.
Okay, you're going to hire your own lawyer?
Yes.
Okay. Now, you're requesting a UJR bond. So, as I explained to the lawyer at the beginning, the process involves you're sitting in jail until I'm able to speak with my boss about your case to make a determination as to whether you qualify. It's her decision to make. Are you sure you want to sit in jail?
Approximately how long do you think that'll be?
Well, the answer will come tomorrow, but the answer may be no, which means you still have to postpone.
Mm-hmm. So I don't think I could get bond posted today. Anyway.
Let me ask you this.
Mm-hmm.
The allegation is that you ripped up legal paperwork and reached across a counter,
Mm-hmm.
Grabbing the wrist and arm of this person. If you have a severe medical condition, why would you be anywhere near that type of behavior?
I'm not admitting to that, Judge.
I'm not, and I didn't say that you did it. I said, why would you be anywhere near that behavior? Because, sir, when there's a decision made about whether you're going to be released on your own recognizance, the idea is that you can conduct yourself in the world. Because the judge will have to be putting her name behind you.
Your Honor, I am, first of all, it was our property.
Don't discuss the facts of the case. Don't discuss the facts of the case.
Okay.
As a judge, I have to take this sworn statement as being true at this moment. Okay. So you are presumed innocent.
Mm-hmm.
But when I'm deciding whether you are a person that could go out into public and conduct yourself accordingly, I have to at least take account that these facts may be true.
Okay.
So why would I think about this? Why would I put my name? And I'm speaking on behalf of the chief. Why would the chief put her name on this behavior?
Because number one, I'm 73 years old. I've been living in the metro area since 1962. I haven't had a case other than a traffic case anywhere in the state of Georgia in 50 years. So other than a traffic case, it's something I've not been in court. I've never been in court in Henry County. I mean, in Clayton County. I have properties in Clayton, Carroll counties, and with my medical condition, I'm going nowhere. I'm a kidney transplant. I require medication twice a day, like every 12 hours, or I have a pacemaker that requires blood thinner every 12 hours. So, I'm not trying to harm anyone. I'm trying to stay alive.
I understand that. I do. But what I often tell people is I can only care about your life so much as you care about your life.
Mhm.
So, you have 10 cycles. You're arrested in 66 on aggravated assault, 75 or fraud. Simple batter. Hold on, sir. Simple batter in 78. Because you've asked for this. So I'm not bringing this out other than the fact that you're asking for this. Pointing a pistol at another in 1986. Simple battery in 19. Let's see. That was the pistol. The simple battery and pointing pistol were dismissed. So, sir, you're not a candidate for an UJR. You're just not. Simple battery in 87, aggravated assault in 89, deposit account fraud in 90.
I don't believe I was convicted on any of those, Your Honor.
Yeah, but sir, there's a whole thing between arrest and conviction. Okay, you're arrested here now, and based upon what you're saying, you're the unluckiest person in the world because you keep getting arrested on stuff.
Well, like I said, I wasn't convicted on any of those.
I know. And as a judge, determining public safety is not about a conviction.
Okay.
It's about the next person that alleges that you did something to them. And the first thing they're going to do is go to the chief and say, why did you let this man out on his own recognizance with this type of history? So, sir, no, your bond set at $4,000. I hope you can make it. And I would encourage you to whatever is in your keeps getting you arrested to change that behavior.
All right, so one other question.
Yes, sir.
That's it. Come on. Get up.
Can I use my own property to make one?
Yes, sir.
Okay.
All right. Yes, sir.
Okay. Mr. Carpio. Okay, sir, you've been charged with 1 count of possession of marijuana less than an ounce. Bond's going to be set at $1,500. 1 count of use of possession of drug-related objects. Bond is going to be set at $1,500. So that's a total bond of $3,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning. Courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
I start tomorrow. I start a job tomorrow.
Okay. I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Okay.
Okay, you're free to go back. Mr. Falls? Sir, you've been charged with 1 count. Good morning. 1 count of burglary. Bond is going to be set at $10,000. Do you believe you can post that bond?
Yes.
Your preliminary hearing date is going to be set for December 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, sir?
Yes, sir.
How much do you make per hour?
I make $13 an hour.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Is it possible? Can I get probation for this? So this is my first offense. You don't do that here. I'm sorry.
Yeah, we're not here to decide your guilt or innocence.
Okay.
Okay.
All this is so I just need to know
Yeah,
that.
but I appointed a lawyer. Speak to the lawyer about that.
Yes, sir.
Okay.
This way, sir. Tell me your name.
Mr. Graham.
Yes, sir.
Is this Mr. Graham?
Yes, sir.
Okay, sir, you've been charged with, looks like 7 driving related offenses.
Yes, sir.
And the bonds are all set by schedule, which means they're automatically set. So you have a reckless driving charge. Bond's going to be set at $1,500. Driving a motor vehicle with an invalid tag. Bond's going to be set at $500. Improper lane change. Bond's going to be set at $500. Driving too fast for conditions. Bond is going to be set at $500. Normally, operating a vehicle. What is this? I'm gonna come back to that and tell you the full charge, but I have to go back and look at the warrant. Bond's going to be set at $1,000 for that. Driving a vehicle without a valid license, bond is going to be set at $1,000. And driving a vehicle with the tag concealed or identity concealed, bond is going to be set at $1,000. Hold on one second. Let me tell you the charge that I missed. It was so long it didn't print out the entire charge on the bond order.
Still been 7 tickets, sir.
I'm sorry, sir.
7, 1, 2, 3, 4, 5, 6, 7 tickets.
All right. It says knowingly driving or operating motor vehicle with a suspended, canceled, or revoked registration. That was the one that I missed. So that is $1,000. So your total bond is going to be, let's see, 2, 3, 4, 5. $5,500. Do you believe you can post that bond?
I thought at least I can post the bond, sir. I own a catering business. And the tickets come in handy where I switch bikes with a guy. I have no knowledge. Explain your case, sir. You actually can be post bond. If I was free, I could post bond. I could pay the tickets, sir.
Okay, so you said you can post bond.
If I was free, I could pay the tickets and take care of the whole thing. I was never served any tickets. I went to the hospital. I've been in the hospital since September. I called the police department twice. So I had no knowledge. Hey, stop talking about your case, sir. I'm talking about your case. So, Mr. Graham,
I'm going to short circuit this a little bit. Okay. These warrants were obtained on September 15th of 2021. And the basic allegation is that you took off on a motorcycle. Okay. So hold on, sir. This is the basic allegation. And so I need you to understand that right now you have a bond set and you're going to have to post that bond to get out of jail. If you do not post that bond, you're going to stay in jail.
That's you could have a signature bond and everything they took care of.
No.
I've been in the hospital the whole time.
I'm sorry to hear that, sir. But the answer is no.
Honestly.
Can you post this bond? Yes or no?
I'll try to have family post the bond.
Okay. Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
I'm sorry, sir?
Yes, sir.
You said you have a catering business?
Yes, sir.
Approximately how much do you make as just a general estimate per month?
$1,000 to $3,000.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Any question you said I don't qualify for the signature bond, right?
Right.
Okay, so I have to sit in here until I go.
Until you post bond.
My bond is set. How much again, sir?
I think it was 4,000. Let me see. 1, 2. 4. Wait a minute.
Listen.
2, 3, 4. $4,500. Is that all? Okay, sir. You're free to go back.
All right, thank you, sir.
You're welcome. All right, Mr. Gutierrez. Good morning, sir. You're charged with 1 count of criminal trespass. Bond is going to be set at $3,000. Do you believe you can post that bond?
Yes.
There's going to be a stay away provision on the bond to stay away from a Hilda Gutierrez. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Are you currently working, sir?
Yes, sir.
About how much do you make per hour?
$14 an hour.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, until when I can come back to the house, until I get the court.
No. So when you're bonding out, make arrangements with the sheriff's department so that you can obtain items from the home that you need for daily living. If Miss Gutierrez is not afraid of you, desires for you to return back to the home, she can contact the solicitor's office and ask them to have this condition either modified or removed. And they will look into it. And if they agree, then they'll do that. As a judge, I really don't have a dog in that fight. I don't care. But what we do is whatever happened that led to you to appear before me today, we don't want that to occur again this evening. So unless and until that is figured out, we place a stay away provision so that at least, because I can place that on you, because if you violate my order, you're going to get aggravated stalking charges and you're going to be sitting in jail until your trial.
Okay.
So you have an incentive to let this whole thing play itself out. But it could be as early as tomorrow that you're back. I don't know. That's up to the solicitor's office.
Okay.
Okay?
All right.
All right, sir. You're free to go back. Mr. Hopes?
Yes, sir. Good morning.
Good morning, sir. You've been charged with 2 counts of criminal trespass. I've set the bond at $5,000 for each offense and 1 count of identity fraud. And I've set the bond at $10,000, and that's a felony offense. So you're going to have a total bond of $20,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for December 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Sir.
Are you currently working?
Yes.
About how much you make per hour?
16 per hour.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, sir, you're free to go back.
Thank you.
You're welcome, Mr. Johnson. Mr. Johnson, sir, you've been charged with 1 count of driving a vehicle without a license. Bond is going to be set at $1,000. 1 count of driving a vehicle with no insurance. Bond is going to be set at $1,000. A third count of a third charge is driving a vehicle on an expired or invalid license. Tag. I'm sorry. Bond's going to be set at $500, and one count of concealing the identity of a vehicle through the use of a false tag. Bond is going to be set at $500. So you're going to have a total bond of $3,000. Do you believe you can post that bond, sir?
Yes, sir.
Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working?
Yes.
About how much you make per hour?
$17 an hour.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
All right. You're free to go back.
Thank you.
You're welcome. Mr. Lewis. Okay, Mr. Lewis, sir, you've been charged with a number of offenses, and I've set bond on all of these offenses, so listen closely. Charged with one count of simple assault, bond is going to be set at $4,000. One count of terrorist threats, which is a felony, bond is going to be set at $5,000. 3 counts of cruelty to children in the 3rd degree. These are misdemeanors. Bond's going to be, bond's going to be set at $3,000 each. 2 counts of battery. Bond's going to be set at $5,000 for each count. 1 count of obstructing or hindering a law enforcement officer, and that's being written as a felony. Bond's going to be set at $4,000. 1 count, final count of giving a false name, address, or date of birth. Bond's going to be set at $2,000. So you're going to have a total bond of, 10, 15, 20, 8. Looks like $34,000. Do you believe you can post that bond? There's going to be a stay away provision on this bond to stay away from a Shatisa Brown. Do you understand that? Your preliminary hearing date is going to be set for December 1st at 8:30 in the morning. Courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
I'm sorry, sir?
Yes, sir. I would.
Are you currently working?
Yes, sir.
About how much you make per hour?
$13.50.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Lovin. Or Lovin. Sir, Lovin. Okay, sir, you're charged with 1 count of battery, family violence. Bond is going to be set at $5,000. Do you believe you can post that bond?
No, sir.
Okay. There's going to be a stay away provision on this bond to stay away from a violet sample. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived if you are able to post bond. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
No, sir. I'm on disability.
Okay. All right. So you do qualify. I'm going to appoint a lawyer to represent you. I would encourage you, sir, to contact the bonding companies and see what arrangements you can make with them. That is their business model to help people get out of jail. So in many instances, they'll place you on a payment plan. They'll do things just as long as they can verify that there's going to be a source of revenue that you can pay their fee. So don't resign yourself to just sitting here in jail, okay?
Well, I was gonna see if I can get it reduced so I can bond out and go to a mental hospital because I have schizophrenia, and that's why the assault happened last night. My meds are off.
Were you off your medications totally, or?
They're just not working. I called the doctor earlier that day and tried to get them to get their doctor's appointment so I can get my medication straight. And they told me I couldn't get a doctor's appointment until November when my scheduled doctor's appointment because of my insurance. I'm diagnosed schizophrenic with homicidal tendencies.
No, I understand. I understand. What medication are you on?
I'm on Depakote, gabapentin, Vistaril, and an anxiety pill. I can't remember the name of it.
Depakote is like a 50-year-old drug. I wish that they would stop placing people on Depakote because it really doesn't work. Okay. If you were to bond out, where are you going to go?
I was going to go to the hospital, one of the local hospitals, and tell them that I need to get admitted to a psychiatric hospital and have them admit me to a psychiatric, do the whole psychiatric thing and go to a psychiatric hospital for 7 days so I can get on my medication straight. The last psychiatric hospital I went to was last year. I went into one and I can't remember the town, but I went to one last year for the same reason. I had got very violent with my fiance Violet.
Right.
Instead of calling the cops, she called the hotline and took me to the hospital, and they hospitalized me instead.
You know, that could have. It's. Do you have? Is she listed as a guardian?
She's listed as my primary caregiver.
Okay. Because the reason I was asking is because based upon what you're telling me, you probably should have been 1013 and sent to a hospital. I'm sympathetic to what you're telling me. The problem is this. I've spent like the last almost 20 years representing people facing the death penalty. And a lot of my clients were like you. And the whole world changes once someone is dead. And people try to help you before, but after they try to bury you. So I'm willing to lower your bond, but the problem that I have is that am I lowering your bond just so you can get arrested again on more serious charges?
No, sir. I'm gonna go and get my medication straight. As long as my medication's straight, I'm fine. If my medication starts slipping again, I'll get hospitalized again. I'm not gonna let this happen again. I don't want to be locked up in Georgia. I've been locked up in Texas plenty of times. I don't want to be locked up in Georgia. That's why I moved here.
There's a medication, and I'm blanking on the name right now. It's a relatively new medication that they give you an injection once a month. So you don't have to worry about taking pills every day or whatever. And I've seen it work wonders. And I've seen it work for people that are in your position. But it's an expensive drug. Each shot is like $2,000. And so because of the cost, people are hesitant to prescribe it. And the way that our healthcare system is set up, they don't give you the best thing, they give you the cheapest thing. So a person in your position ends up going back and forth with things that don't work. Or, as I stated before, drugs that are invented 50 years ago. So what I'm going to do, Mr. Lovin, is I'm going to reduce the bond to $2,500. You sound like you have a plan in place to get the treatment that you need. I would just caution you that you need to follow through with it, because being mentally ill is not a defense to murder. And it really isn't. It's a whole lot that has to go in place with that. And knowing that you are supposed to be on medication, actually, there's a statute that allows the state to use that to negate your defense. Because they say, well, he was told he's supposed to be on the medication. He wasn't on the medication by choice. So you're free to go back, sir. Did I appoint you a lawyer? Yes, I did. You're free to go back, sir.
All right, thank you.
You're welcome. All right. Is Mr. Martinez Cruz OTB?
Who's calling, sir?
He bonded out.
Who?
Martinez Cruz.
Yes, sir. I believe so. Yes, sir.
Okay. And is Mr. Mateos also OTB?
Yes, sir.
Okay. All right. Thank you. Mr. Shepard Tigner.
He's on his way, sir.
Okay.
How you doing, sir?
I'm doing well. So you're charged one count of simple possession. Bond is going to be set at $3,000, and one count of obstructing an officer. Bond is going to be set at $2,000 for a total bond of $5,000. Do you believe you can post that bond? I'm sorry, sir.
15%.
All I heard was 750.
I said, will the 15% be 750?
Of 5,000.
Around how much?
Yeah, it wouldn't be seven. You said 750. It's somewhere around there.
Okay, yeah, I'll be able to make one.
Okay. There's going to be a preliminary hearing date set for December 1st at 8:30 in the morning, because the simple possession is a felony offense. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, Mr. Shepard Tigner?
After yesterday, no.
Okay. I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
No, sir.
Okay, you're free to go back. Mr. Smith.
You want to take me?
Mr. Smith, hi, sir. You're charged with one count of simple assault. Bond is going to be set at $4,000. Do you believe you can post that bond?
No, sir.
Okay. There's going to be a stay away provision on this bond to stay away from a Janae Smith. Do you understand that?
Yes.
Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working?
Yes.
About how much do you make per hour?
14.
Okay. You do qualify for a lawyer. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date set for November 30th at 8:30 in the morning, courtroom 201. I would encourage you, sir, to contact the bonding companies, because they, as I stated to the other gentleman, they will work with you. So don't resign yourself to sitting here in jail.
Most possibility about reducing it, because I just lost my dad. His funeral is tomorrow, and I don't want to be in the funeral of the death of my dad, man. It was all a big misunderstanding. Actually, I called him back.
You called the police?
Yes. Yes.
I'll tell you this, Mr. Smith. Once you, as an adult, once you call the police, you're bringing another person into the situation, and that person has the ability to do whatever they want to do. Okay, I'm sorry to hear about your father, but I would encourage you to make those arrangements so that you can get out.
Okay.
Okay. All right, sir. You're free to go back. Mr. Snyder.
Yes, sir.
Sir, you're charged with one count of battery. Bond's going to be set at $5,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond, a stay away from a Lashari Kochinsky. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
Yes, sir.
About how much do you make per hour?
$18 an hour.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir, I do. What type of payment plan do bonding companies normally set?
Well, it's generally based upon your financial situation. They ask you questions, and then they'll say, okay, well, you can pay X dollars every week or X dollars every month. It depends upon the bonding company. So that's why you got to do the legwork in calling them.
What requirements do you got to have for someone to bond you out? For them to bond you out?
So each bonding company, it's a private business, so they make their own rules. So one bonding company may say yes to you, and another bonding company may say no, but the criteria is the same. So it's up to them to make that determination. Okay. So if you're like in bankruptcy, you got all of this stuff, you're not paying your bills, you're not doing any stuff, they may not take a chance on you. Okay.
Yes, sir.
All right. So you gotta make the phone calls, you gotta ask questions.
Yes, sir.
All right, sir. Be free to go back.
You have a go.
You too. Mr. Strawbridge.
Yes, sir.
So you're charged with one count of criminal attempt as a felony. And this was an interesting charge. And I set the bond at $10,000. Do you believe you can post that bond?
No, sir.
Your preliminary hearing date is going to be set for December 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond out, or you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
I would, sir. I also have a question for you.
Okay. We'll get to that. Are you currently working?
Yes, sir.
About how much do you make per hour?
I'm just getting out of training, so it's a salary and sales position. So right now I'm doing $1,000 a week. After the training, I do more. But with this case, I'm probably going to lose that whole position.
Okay. I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. So what was your question?
Okay. My question is, if I could get a bond, signature bond based off the fact that, without going into the details of the case, I called the officer to ask him if I could, pull my own furniture at my own house without getting to the details. I got the approval to do what I did. which, and now I'm here. I know we can't get into the details of the case, and I'm not a flight risk. You can see my record there. There's nothing on there that would even insinuate that. I work with the public on a daily basis, every day, with the company that I work for.
Give me a second. I'm getting to your criminal history. This is do you know Mr. Elliott?
The Airbnb customer, yes, sir. And I've been going back and forth at Airbnb because they don't even believe that he's still there. I'm going back and forth between Eric, because he's an Airbnb customer that would not leave the house. So I'm going back and forth with Clayton County, Airbnb. So yes, I do know Mr. Elliott.
Awesome, bro.
And if the Airbnb would just, I told them to try to get called down here and tell them what's going on, but they don't want to get involved, even though he's their customer. This whole real estate thing went bad.
God bless you, brother. Oh, man.
So, Mr. Strawbridge, what I'll do is I'll reduce this to $5,000. It's not going to be a signature bond.
Is there any way you reduce the actual charge itself?
No, not at this stage.
At this stage?
No, because this is a one-sided thing. I have the allegation. This warrant was written on July 25th of 2021. And the allegation basically is that you it's the allegation, which part of it doesn't make sense to me, because it says that you attempted to take Mr. Elliott's bed, his MacBook Air, and a Michael Kors watch. So that whole thing really doesn't make a lot of sense to me, but
Doesn't make sense. Doesn't make sense at all, sir.
This was brought to another judge, and the judge passed on it.
It's an Airbnb customer. You can't even have your own bed, so that definitely doesn't make sense. But it's not the time to discuss that.
Right. And it essentially, the allegation, and there is a witness, Mr. Franklin, but there's an allegation of an eviction that was not done properly or appropriately. And I'm assuming, based upon the allegation, that you own the home?
No, sir, I was renting a home, but no one was being evicted. The
Okay.
officer let me know that no one's being evicted. I was just, yeah, I was
Okay.
yeah.
No, and so this is why we have a legal system to deal with these types of issues, and so it'll get worked out through that. But you're free to go back, sir.
Okay, and bond is 5,000?
Yes, sir.
Thank you,
Mr.
sir.
Tucker.
Proper time to leave.
Is he there? It looks like he was on yesterday and was continued.
He's here, sir. He's here.
Okay.
You got it, right? Yeah. So there's a police all of you. Yeah.
Yes, sir.
Mr. Tucker, sir, looks like you were on yesterday's calendar. You've been charged with one count of theft by taking. Bond's going to be set at, it's a felony. Bond's going to be set at $10,000. One count of giving a false name, address, or date of birth. Bond's going to be set at $2,000. And one count of crossing the roadway, which is basically driving on the wrong side of the road. Bond's going to be set at $500. So you're going to have a total bond of $12,500.
Hold on, Walker, you said Jay Walker.
Yeah, it's just that's what it is.
Okay. $500. Bond's you had a total bond of $12,500. You believe you can post that bond?
No.
Your preliminary hearing date is going to be set for December 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay. I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, sir, you're free to go back. Mr. Waller.
Yeah.
Williams here. Is it?
Yeah.
So you've been charged with one count of entering an automobile, which is a felony offense. Bond is going to be set at $10,000. Do you believe you can post that bond?
Yes, but I have to do it like kind of like as far as like you know, like doing different types of like stuff.
Okay. Your preliminary hearing date is going to be set for December 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer, Mr. Waller?
Yeah.
Are you currently working, sir?
Yeah, right now, yeah. I'm doing like.
How much do you make per hour?
How much I make per hour?
I'm sorry?
How much I make per hour?
Yes, sir.
I make like decent.
Okay. I didn't understand that answer, but I'm going to find that you qualify for the appointment of a lawyer. You're free to go back, Mr. Waller.
Go ahead. Just go to that. We won't give you a cell.
Mr. Williams?
How you doing today, Mr. How you doing today,
I'm doing well, sir. You've been charged with one count of criminal trespass. I've set a $1,000 bond. Do you believe you can post that bond?
I can't post that bond. I don't have any funds right now. I just, I re-enlisted the day before I got arrested, it was 2 o'clock in the morning when I got arrested. But I was just walking down the street in the neighborhood where I live at, where I dwell at. My fiance stays there, and I was with her. She was doing my hair, and now my hair looks crazy because I was walking to get some water. I just woke up at like 1 in the morning, walking to QT, get some water. I see the police, and I just get on my knees because they just stand there. They started to get out the car like past me. No probable cause. I don't know what's going on.
Okay, so the allegation, Mr. Williams, is that you returned to this South Lake Cove court address after you had been given. Sir, you said you don't know what's going on. I'm trying to explain it to you. So please stop talking.
Yes, Your Honor.
Says you were given a criminal trespass warning not to return back to that property on October 19th of 2021 after a domestic dispute. And it says there's a case number that they have. So that's why you were arrested. Okay. That's the allegation.
I thought I was detained. Excuse me. Sorry.
I'm sorry, sir.
They told me I was being detained. That I was going home. I've been here for 48 hours.
Well, that generally what happens before you get arrested. The being detained so they can investigate the situation. And after they investigate the situation, if they determine there is no probable cause to arrest you, they will release you. If after being detained and they do their investigation, they determine that there is a reason to arrest you, you will be arrested.
I was on the phone with my lawyer when they arrested me. So,
you did what?
I was on the phone with my lawyer when they arrested me. I was talking on the phone about business.
Okay, so being on the phone with your lawyer doesn't stop you from being arrested.
No,
as you now have figured that out.
I never had a chance to call my lawyer again because they wouldn't let me use the phone. And then when
they don't have to.
I thought I did a free phone call. Okay.
Mr. Williams, you're a young man.
Yes, Your Honor.
And there is a whole lot of assumptions that you're making.
Yes, Your Honor.
I'm old enough to be your father at this point.
My father's 63 years old, Your Honor.
That's fine, sir. I'm old enough to be your father.
Yes, Your Honor.
Okay? I was in my 20s when you were born.
Yes, Your Honor.
Do you see where this is going? It seems, sir, you have a whole lot of input, but not a whole lot of wisdom.
Right.
And at some point in your life, you're going to have to learn that it's best to keep your mouth shut and to learn than to start spouting erroneous. There you go again. You can't keep your mouth shut. And as long as you keep doing that, you're going to be seeing people like me for the rest of your life. And I hope that you understand sitting in jail is not where you want to live your life. But as long as you keep on talking and as long as you keep on telling people that know what they're telling you that they don't know, you're going to be in jail. And I'm sorry that that's going to happen. There's going to be a stay away provision on this bond because it lists David Williams as the victim. So I assume, is that your father?
My father's name is Major.
Okay. So I'm going to place on here a stay away provision for you to stay away from
South Lake.
4601 South Lake Cove Court, Jonesboro, Georgia. Now, let me explain to you what that means. If you go back over there with this stay away provision in place, you'll be charged with what's called aggravated stalking, which is a felony. And there's no bond on an aggravated stalking charge. So, if you go back over there, you're going to be arrested on aggravated stalking. You're going to be placed in jail without bond until your trial or until your lawyer gets you out. Do you understand that, Mr. Williams?
Yes, Your Honor.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir. Yes, sir.
Are you currently working?
I'm trying to find work now, but I was talking to my life coach about that, figuring out what I need to do.
Okay, so that's a no. Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out of jail, and you'll get a new court date in the mail.
What's the bond, sir?
$1,000.
Is there any way I can get that a little lower so I can pay a cash bond at the jail possibly?
No, Mr. Williams.
Thank you, sir.
You're welcome.
God bless you.
You too.
There are two fugitives, sir.
Yes, sir.
Both of you.
No, both are true. They're gonna do it both at the same time. No, it's the same differences.
Okay, so I have a Mr. Ellis and a Mr. Johnson. Mr. Ellis, would you raise your hand for me, please, sir?
My name is Martell.
Hey, Frank.
Martell Ellis.
The way it's written here is that your first name is Martell and your last name is Ellis.
Yeah, that would be correct.
That's it.
But and then this is misspelled as well. This is like Elice.
Hold on. So what's your last name?
Ellis.
You said your name was Martell.
Yeah. My first name is Martell.
So, sir,
I don't have that on my paper.
I give people the respect of referring to them as Mr. or Mrs. I'm not your friend. You're not Martell to me. You're Mr. Ellis.
Well,
Okay. That's what the thing is. Calm down. Relax. Listen to the judge. Enough.
Okay. Mr. Ellis, I'm going to give you an opportunity to speak in a second, okay? You can tell me whatever you want to tell me until you get tired of talking. And I'm going to sit here with my mouth closed and I'm going to listen. Okay, sir? And Mr. Johnson.
yes.
Mr. Ellis, the both of you are here on what's called a fugitive from justice warrant. And what that means is that you're basically wanted. There's a warrant for your arrest out of another state. And the state of Georgia has an obligation to hold you for that requesting jurisdiction because they have indicated in both of your cases that they wish to extradite you. In Mr. Ellis's situation, there is a warrant for hit and run out of the state of Illinois. For Mr. Johnson, there is a warrant for your arrest out of for violation of probation. And it looks like it's out of Virginia. So both jurisdictions have indicated that they wish to extradite you. And what that means is that they wish to bring you back to their state for you to be to face these charges. The issue of bond is not being determined here in this jurisdiction. However, you can, if you were to hire a lawyer, have someone advocate for you, Mr. Ellis in Illinois, or Mr. In Virginia for Mr. Johnson, they can set bond. And if they set bond, they'll notify the sheriff's department here, hey, cut them loose. We've set a bond, and you get to walk out the front door, and that's done. If you believe that you're not the person named in the warrant, if you're not Mr. Martell Ellis or Mr. Joseph Johnson, or if you believe that these charges are not valid, you have a right to challenge this process through a writ of habeas corpus. And what that basically means is that if you tell me now, hey, Judge, I want to challenge this, sometime between now and the next 90 days, there will be a hearing held. The judge at that hearing is going to make basically two determinations. One, whether you're the person named in the warrant. Two, whether the warrant is valid, meaning there are charges that you can be prosecuted upon. We don't make any determination about whether you're guilty or innocent. If at the end of that hearing, sometime within the next 90 days, the judge determines that those two factors exist, the judge will then sign off on the extradition, and the state of Illinois and the state of Virginia will have a statutory period beginning at 30 days to come and get you. They can request an additional 60 days to come and get you. Or you can say today, hey, I believe I'm the person named in the warrant. I believe the warrant that these charges are valid. I'm going to waive that process. I'm going to go back up there and I'm going to fight these charges. If you were to do that, the clock begins to run today for that 30-day period. At the end of that 30-day period, each state has a right to request an additional 30 days. But if they do not come and get you, you could be released out the front door by the sheriff's department. But it doesn't make the warrant go away. So you can get released out the front door. 5 minutes later, you run into another law enforcement officer. Officer runs your information, finds that there is a valid warrant. You get brought right back, and the process starts all over again. Am I making sense to both of you about this? Mr. Ellis, you had a question. What was your question, sir?
Well, I have waived your extradition papers and a bunch of things in my name, but like my name is not spelled correctly on here, so I don't really know what it is. If I sign a waiver of extradition, then does that enable me to fight the case here in Georgia? Because today is my off day at work, and I have to be at work in the morning.
Okay, so Mr. Ellis, if you believe that you're not the person named in this warrant, you have a right to challenge this process, but you will remain in custody sometime between now and the next 90 days to have that hearing.
Yeah. Okay. So yeah. So I'm not getting a bond or anything today?
No, sir. So Mr. Ellis, so I don't know you. I don't know if you've ever been to the state of Illinois. If you have never been to the state of Illinois, then maybe you want to challenge this. But this is not the time to have that hearing, because what happens is that if you want that hearing, state of Illinois gets contacted. They bring the information to say that you are the person that they are looking for. And that's it. That's what the judge will be listening for. So my name ain't spelled right and all of that kind of stuff, that's for the hearing to be determined. So I'm just telling you, if you've never been to the state of Illinois, you think this is wrong, hire a lawyer and fight this. If you've been to the state of Illinois, if you believe that this is true, you're going to set yourself up for possibly 6 months in jail before you even get to deal with this.
Yeah, I read them up 30 days to just start today so I can get all this stuff out the way. Because I just want to get it on out the way. It's not something that is going to stick with me at all. It's just, I moved to Georgia to start a new life and get on my feet and kind of build here. So it's like, nothing because I got to leave everything.
Mr. Ellis, do you have something to write with and something to write down?
Yes.
Okay. This is the warrant number. It's W09195545. I would encourage you to get a lawyer up in Illinois to deal with this, because they may grant you a bond rather than having to expend the money to come and get you and pick you up. And then you get to go back to work, you get to do what you need to do. And then when your court date comes up to Illinois, you're going to have to go up there to go to court. But if you have a lawyer, the lawyer may get the judge to agree that you don't have to appear.
Yeah, I'm gonna look into it more. I appreciate it.
Okay, so you're gonna sign the waiver.
For extradition.
Yes, sir. And by signing the waiver, it gives you another possibly a point of leverage, because now that you've signed the waiver, the clock is ticking and they know they have to come and get you. And so they may decide, look, we don't want to go down there. We don't do this, we want to do that. Let's just, let's agree to set him a bond. But you got to get a lawyer. You got to get somebody to advocate on your behalf.
Absolutely.
Okay. All right, Mr. Johnson, do you know what you want to do, sir?
Yes, I'm sorry.
Okay. Once you sign the waiver, Mr. Johnson and Mr. Ellis, they will allow you to go back. And I encourage you, Mr. Johnson, also to hire a lawyer to deal with this issue.
Yeah.
So at least you have somebody working on your behalf.
Yeah.
Okay. That is it.
Yes, sir. That's it, sir.
All right. Thank you for your assistance. I'm going to have my first day off for the year tomorrow.
Oh, my God. Enjoy it, sir.
I'm going to lose my mind.
Enjoy it.
All right. Have a good
morning.
Good morning.
How are you this morning?
I'm good. How are you?
I'm doing great. Thank you for keeping me safe. Yes, I'm ready for Mr. Smith. Mr. Smith, you can approach.
Okay, yes, please. He's at the podium.
Good morning, ma'am.
Good morning. Can you raise your right hand for me, please?
You do solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, self be God?
Yes, ma'am.
All right, PD withdrew on this case.
Right. On the 20th.
Was there a conflict, or do you have a private attorney, sir?
Right at the moment, I don't know whether or not I got a private attorney or not. But
No worries. We've sent you to another attorney just because there was a conflict. So we're going to sign an order to get you a new attorney, okay?
Yes, ma'am. Can I just ask one question if you don't mind?
So, yeah, I do. So I want to make sure that you have an attorney when you are talking to me, okay? So that you can be represented, and that's what I'm going to do for you today, all right?
Okay.
So do you,
But that's
I can
that's
waive
what
his
I was
agreement.
getting to is about.
We have one. So if you want a private, so what I'm going to do is I'm going to appoint you to one, and then anytime you want to get a private attorney, you can.
Okay, all right, thank you. All right.
So I'm just going to reset this until he has an attorney. And I'll reset it.
Okay.
Thank you very much.
Your Honor?
Am I being arraigned on these charges?
Yeah, well, technically, I'm going to provisionally appoint you to the Office of the Public Defender, but the Public Defender withdrew.
Okay.
So if you give me a moment, I'm going to send you to Regional Conflicts Counsel to give you another attorney at this time, but I'm sure, Mr. Good morning, Counsel,
Your Honor, Matt Kazare for the state. I'm standing in for Linda Drain Burdick on this case. Good morning. No objection to resetting the arraignment or to arraigning him today, but there is a co-defendant in this case that's over in Judge Karsten's courtroom. I see that a motion to transfer was filed yesterday. I just reached out to the public defender who's on that case. They have no objection to the motion to transfer. I've got a proposed order here.
Perfect.
We can just get them all together.
Thank you. So we got you together, all right?
Okay, thank you very much.
Of course.
All right.
Next case.
Thank you, Judge.
Thank you. Next case.
To the front of the docket, for the beginning.
All right, Judge, are we resetting?
We are resetting this. We are resetting this, and I have signed your order for administrative transfer between the divisions, and I'm going to give that to the clerk right now.
Thank you, Your Honor.
Thank you.
Page 1, 21 CF 2561, Cedric Beverly.
Good morning, Mr. Beverly.
He's approaching the stand.
Good morning.
Good morning. Can you raise your right hand for me, please?
You do solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, Mr. Beverly, you are here as you were charged with attempted first-degree murder with a firearm, shooting at, within, or at an occupied vehicle, and possession of a firearm by a convicted felon. At this time, PD approved?
It states that he's to hire his own attorney, so they would need to.
I'm going to provisionally appoint you to the Office of the Public Defender today. At any time you want a private attorney, you can get a private attorney, okay?
Morning, Your Honor.
Good morning.
Elkis Izquierdo on behalf of Mr. Beverly. At this time, we're entering not guilty for purposes of arraignment.
All right, so your attorney, I have provisionally appointed you to your attorney. She's going to announce her name for you on the record so you can hear her name. Make sure you listen, okay? And then enter the following on his behalf.
Elkis Izquierdo on behalf of Mr. Beverly, not guilty.
Thank you. So did you hear your attorney's name at this time? Okay. And she entered a not guilty for you. Listen to the following dates, okay?
Pretrial will be set for January 19. Trial period begins January 31st.
All right, good luck. Next case.
21 CF 2623, Daira Colon Gonzalez.
Honor, Ms. Colon Gonzalez is present and approaching.
Good morning, Ms. Gonzalez.
Yes, PD approved.
You're going to put your purse right there, okay? Good morning. It's all right.
You can leave.
You can put it right there. Okay, it's first time. I can already point out the first timers.
Yeah.
Put your right hand up for me, please.
You do solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
All right. Can you state your true name and date of birth? True name for me, please. Gonzalez.
Daira Colon Gonzalez.
All right, Ms. Colon Gonzalez, you were here as you were charged with neglect of a child, a third-degree felony. At this time, I'm going to provisionally appoint you to the Office of the Public Defender. She's standing right next to you. She's going to announce her name. She's going to enter the following on your behalf, okay?
Thank you.
Elkis Izquierdo on behalf of Ms. Colon Gonzalez. At this time, we're entering a not guilty. Also, Your Honor, we have submitted to the state a joint stip signed in order for Ms. Colon Gonzalez to enter pretrial diversion.
Yes, Judge.
All right, so I have an order here from the state. Look at that. So I hope your attorney will let you explain to you what this actually means. And at this time, I'm going to provisionally appoint the Office of the Public Defender, and I've signed your joint stipulation for continuance and abeyance. And this will be removed from my docket. All right, Ms. Colon Gonzalez, good luck, okay?
Thank you.
Please wait for your paperwork, though.
You're welcome. Thank you, Your Honor.
Have a good day.
2017 CF 4202 Clayton Frye.
Good morning, Judge. Peter Schmier from Mr. Frye.
I knew that was you. Good morning.
I look a little bit different. I just came
Welcome back.
Well, thank
I
you.
didn't want to say it, but I didn't know to say it. I saw that was you. How are you
Thank you.
doing today?
I'm feeling a lot better. Thank
I am so glad to see you.
you. Likewise.
All right.
I just got cleared to return from the doctor's
Excellent.
office.
Today?
Oh, I came back about
Today?
10 days ago. I was out for 3.5 months.
Wow. One day,
Ugh.
I'm gonna need you to, if you get cleared, don't come back today. That's okay.
Exactly.
I'm glad you're back.
Thank you.
All right. Where are we? I'm so sorry. I knew that was.
For Mr. Frye's case,
Thank you.
it's a VOP Raymond, I guess.
All right, Mr. Frye.
He's in, he must be in jail. It's a no bond warrant.
Mr. Frye? Not here?
No, no, ma'am.
So the office was just appointed on Friday, Judge, and I got the case like basically at 5 p.m. I've had no chance to talk to him yet.
He's not there.
Well, I would enter a denial on his behalf, and I will see him in a few days.
All right, let's set your pre-trial.
No, this is a VOP case, Judge.
Set the VOP status.
January 27th.
January 27th. So I don't even have the new calendar.
And Your Honor?
Is that good? Yes.
Dates work for state. I just wanted to let you know, it looks like the VOP warrant did have a bond and he did post bond actually yesterday. The bondsman got notice this morning. I have no objection to defense entering a waiver. I just wanted to let the court know that's where Mr. Frye is. He was able to bond.
Thank you very much. Let me see though. I would like to see him a little sooner than January though.
December 16th.
Yeah. Let's do December 16th at 9:30.
Thank you.
Haven't seen him yet. All right. Next case.
It's 21 CF 2021 Michael Hernandez Rivera.
Good morning, sir.
Good morning, ma'am.
Can you raise your right hand for me, please?
Yes, ma'am.
You do solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, you are here as you were charged with possession of cocaine and possession of third-degree felony and possession of drug paraphernalia, a first-degree misdemeanor. At this time, I'm going to provisionally appoint you to the Office of the Public Defender. Your attorney is here inside of courtroom 5A, and she's going to announce her name for you, so make sure you listen, and she's going to enter the following on your behalf. Counsel.
Emily Adams from the Office of the Public Defender, and we will enter a not guilty on Mr. Hernandez's behalf today.
All right, Mr. Hernandez, are you able to hear your attorney's name?
Ask her to repeat it, please.
No, I didn't heard on my attorney's name.
Okay, no worries. Can you repeat your name for him, please?
Yes, Emily Adams from the Office of the Public Defender. This case is still in intake, Your Honor, so it's not necessarily assigned to me, but it will be assigned to one of us.
All right, so right now your attorney is Emily Adams.
Emily Adams?
Yes, sir.
All right.
And if that's not your attorney, make sure this is your case, your life. So you make sure you follow up with the attorney and listen for the following dates. Madam Clerk.
Pretrial in this case will be set for January 19. Trial period begins January 31st.
Good luck, sir.
21 CF 2034 Daniel Howard.
Emily Adams on behalf of Mr. Howard. He's present and approaching, Your Honor.
Mr. Howard,
Good morning, Your Honor.
please raise your right hand for me.
You solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right, Mr. Howard, you were here as you were charged with a failure of a sex offender to report to the sheriff's office during the birth month and during every... Give me one moment. During birth month and during every third month after the birth month. This is a third-degree felony. At this time, I'm going to appoint you to the Office of the Public Defender. PD approved?
Yes, since September 29th.
Okay. And your attorney is standing next to you.
Yes,
She's
ma'am.
going to announce her name,
Yes, ma'am.
and then she's going to enter the following on your behalf.
Emily Adams on behalf of Mr. Howard, and it's a not guilty today, Your Honor.
Right. All right, Mr. Howard.
Yes, ma'am.
It's very important that you stay in contact with your attorney, okay?
Yes, ma'am.
And listen for the following date, Madam Clerk.
January 19. Trial period begins January 31st.
January 19th, okay? Please wait for your paperwork.
Yes,
Look, sir. Next case.
2019 CF 24 Jean Martinez Muriel.
Maria Morales on behalf of the state.
Vasquez Izquierdo from the Public Defender's Office.
Good morning, sir. Can you raise your right hand for me, please?
Good morning, miss. I'm so sorry, but you don't have translated, but I know understand.
No. Un momentito.
Thank you, miss. I appreciate it. Sorry.
Good morning, Your Honor. This is Laura Royo, State Certified Interpreter and previously sworn.
Good morning. How are you doing today? We have
Good, Your Honor.
case number 49 We have case number 49, 2019, CF 024, Mr. Jean Carlos Martinez Morale. He is currently speaking to you from the Osceola Corrections Facility, and you will be translating over the speaker system.
Yes, Your Honor.
Mr. Martinez Morale, alto. Can you please raise your right hand?
You do solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Señor Martínez Moral, por favor, levante la mano derecha. ¿Jura usted solemnemente que la declaración que rendirá será la verdad, toda la verdad y más la verdad?
Yes, ma'am.
¿Perdón?
Correcto. Yes.
Correct. Yes.
Okay, you are here as you were charged with grand theft of $100 or more from dwelling or curtilage, a third-degree felony.
Usted se encuentra aquí por hurto de mayor cuantía de $100 o más de un inmueble o un inmueble conectado, delito grave de tercer grado.
Your attorney is here inside of...
Your Honor, I apologize for interrupting, but this is a violation of probation.
So I'm so sorry, I'm looking at something else then. Give me one moment. What's his name?
Jean Carlos Martinez Morale. It's the
Me disculpo por interrumpir su señoría, pero este caso
I'm sorry.
en realidad es por incumplimiento del régimen de libertad vigilada.
So give me 1 minute. So we were looking at the information that was filed in April 29, 2019. That's not the information. It's.
I believe there was a violation of probation affidavit.
It's
October 20th.
Yeah, it's okay. She was distracted. Okay, sorry. Yep, no worries. That happens. Sorry about that. Yep, no worries.
Me disculpo por ello.
I apologize. That was my fault.
Me disculpo porque la culpa era mía.
You are here as you were charged with a violation of condition number 5 of the order of probation.
Usted se encuentra aquí por haber incumplido la quinta condición de la orden del régimen de libertad vigilada.
By failing to live without violating any law.
Por faltar en vivir sin infringir ninguna ley.
By committing the criminal offense of battery, touch, or strike.
Y por cometer el ilícito de agresión física al tocar o golpear un tercero.
At this time, I'm going to appoint you to the Office of the Public Defender.
En este momento dado se le designa la Oficina de Defensores Públicos.
Your attorney is here inside of courtroom 5A today.
Se encuentra aquí hoy día en la sala 5A la abogada suya.
She's going to announce her name and enter the following on your behalf.
Ella va a pronunciar su nombre y asentará en actas lo siguiente de parte de usted.
Counter.
Vasquez Izquierdo on behalf of Mr. Martinez Morale. At this time, we're entering a denial.
Licenciada Izquierdo, de parte del señor Martínez, en este momento dado estamos asentando una declaración de denegación.
It's very important that you stay in contact with your attorney and listen for the following date, Madam Clerk.
Es sumamente importante que usted mantenga contacto con la licenciada suya y ahora que escuche usted a las siguientes fechas que se van a pronunciar.
VOP status hearing will be set for December 16th at 9:30.
La vista de seguimiento por incumplimiento de su régimen se fijará para el 16 de diciembre a las 9:30.
Good luck, sir.
Buena suerte, señor.
Thank you, Your Honor.
Thank you. Thank you, Mrs. Interpreter. Have a great rest of your day.
You're welcome.
2017 CF 2178, Terry Lee Mashburn.
Good morning, sir. Can you raise your right hand for me, please?
You do solemnly swear or affirm testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Habla español.
Maybe you can't hear. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
It's muted. All right. Again.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Mr. Mashburn, you are here as you were charged with the following: a violation of condition number 5 of your order of probation by failing to live without violating any law, by being charged with a criminal offense of violation of an injunction or lesser included offense. At this time, your attorney is in courtroom 5A. She's going to announce her name for the record and enter the following on your behalf.
Emily Adams on behalf of Mr. Mashburn, and we will enter denial today, Your Honor.
All right, did you hear your attorney's name?
Yes.
Okay, she's entered a denial on your behalf. Listen for the following date, okay, Mr. Mashburn?
Yes.
DOP status will be set for December 16th at 9:30.
December the 16th at 9:30. Good luck, sir.
Thank you.
Thank you.
2019 CF 3603, Naomi Mercado Alvarez.
Judge Peter Smith from Ms. Alvarez. So we were appointed on this case. I met with her on Friday night. Apparently she was declared not indigent because her affidavit of insolvency was incomplete. I know that the social worker went to see her to fill out another one. So she's asking to be reappointed. She has not worked for 5 years, apparently because of the mental health issue. So she has no assets.
Okay, so I'm looking at the affidavit right now. I will, because you're redoing it, I'll provisionally appoint her. Give me one moment. Okay, Ms. Alvarez, can you raise your right hand for me? Pardon me, Ms. Naomi Mercado Alvarez, can you please raise your right hand?
You do solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Thank you. You were here as you were charged with the following. Count 1 is scheme to defraud of $50,000 or more. First degree felony. Charge 2 is false and fraudulent insurance claims. First degree felony. Charge 3 is grand theft, first degree, $100,000 or more. First degree felony. And 4th is operating a clinic without a license, which is a 3rd degree felony. At this time, you're going to be resubmitting your application to the clerk's office, so I'm going to provisionally appoint you to the Office of the Public Defender. Your attorney is inside of courtroom 5A. He's going to announce his name for the record and enter the following on your behalf. Please pay attention.
Judge Peter Smith, for the record, I've met Ms. Alvarez already at the jail. At this point, we're not going to enter into a plea because the rules of criminal procedure state that we need to file either before or at an arraignment any possible motions to dismiss. In fact, did file a motion to dismiss yesterday as to all 4 counts.
Give me one moment. Let me see the motion.
So we need to have that set for a hearing.
Rachel Climbier on behalf of the state on behalf of Lindsay Card.
I see. Okay, I do see the motion to dismiss. Did you already set it?
No, because I filed it yesterday. The motion is straightforward. It's a statute of limitations argument.
So I do have a new JA. Be nice to him.
Yeah, I'm always
His name is Andrew.
Okay.
And you can go ahead and set that with him, okay?
Okay, will do.
Thank you.
Thank you.
Right, there's going to be, your attorney is going to resubmit your application, because right now we don't have a valid application. And 2, there is going to be a hearing for a motion to dismiss your information. Okay? Thank you, good luck.
Thank you, Your Honor.
Yeah, let's do it, because we still have that one control. The status?
Okay, thank you.
Thank you, that's it. Have a great rest of your day.
No talking in the gallery.
We can do a status. We can do the status, if he's here. Status?
Yes. You set it? Want to just set it?
For what, this case?
Yeah.
Yes. Attorney Smear? Attorney Smear, I'm going to set a status. Attorney Smear, I am going to set a status, though, just so I can keep up with the case, just in case something happens. And that is going to be, Madam Clerk, let's do it sooner than later. A week. Mm-hmm. The 8th, maybe?
Yeah, November 8th.
November 8th at 9:30. State, did you hear the date?
November 8th at 9:30, passed it on to Ms. Carter already.
Oh, yes, thank you. All right.
21 CF 2750, Rebecca Wagner.
Emily Adams on behalf of Ms. Wagner. I'm unsure if she received notice for today's court date, Your Honor. I believe she just recently bonded. But I have no information from the court, for the court.
Well, let's check. Oh. Did you, Madam Clerk, let's see the date that the notice went out.
It was set October 8th. And the notice for the bond was set on the 18th.
So she received notice on the 8th and October 18th.
Understood, Your Honor.
So at this time, I'm going to enter a capias. Well, let's call the Halls. Maybe she's out there. Let's give her a little bit of, let's give her some time.
Wagner.
We're just going to call the Halls and give her some time, make sure that she's not anywhere in the vicinity. Do we get any return mail? Thank you. At this time, with no return mail, no response, and a notice of the court date to the bondsman, I'm going to enter a capias for Mrs. Rebecca Wagner, and I'm going to enter a bond of $2,000 for failure to appear. All right.
Next case is 21 CF 2902, Hector Alvarez.
Good morning, sir.
Good morning, Your Honor.
Can you please raise your right hand?
Yes, I am.
You do solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
The motion for the reduction of the bond.
Yes, Your Honor. Regarding the motion, it's my understanding that the jail will take about an hour in order for Mr. Alvarez to be present for his hearing. I understand, Your Honor.
You want him
physically present? Yes. In addition, Your Honor, I had requested for Mr. Warren Lamb to be added to Your Honor's docket for a motion for non-monetary release conditions. I did follow up with your judicial assistant, and I apologize if I butcher his last name, Mr. Borgerali. Yes, and I also confirmed with the clerk that although the case is not on the docket, he was calendared for today. In addition, it will also take an hour for him to arrive in the courtroom to be physically present for his hearing. So I am requesting for us either to perhaps come back this afternoon for both of them to be physically present for their hearings, or in an hour. I'm not sure.
11:30. All right, I'll give him 11:30. I should give him more than a little bit. All right. And then, I mean, we can do the motion for, okay. You want him here? We can have him here. Yep.
And I'm sorry.
So they're going to bring him.
Thank you, Your Honor.
All right, Mr. Alvarez, it looks like you're going to be here for your motion. Who's the state on this case?
I believe it's Ms. Klein-Peter.
I'm here, Your Honor. I'll be here. Yeah.
Perfect.
No problem.
So motion for reduction of bond. Mr. Alvarez, I'm going to see you in an hour.
Awesome. Thank you. God bless.
And also, Your Honor, for Mr. Lamb as well, correct?
Sure. You have Lamb?
Because I see Mr. Lamb present on the jail feed.
I mean, I don't have Mr. Lamb on my docket, so.
Add-on docket you have.
Oh, I'm sorry. Let's see here.
Just the claims. I thought they had to be in person.
And this one is for non-monetary release?
Okay. Your Honor, if I may,
He's right there.
I
Good morning,
understand.
Mr. Lamb. Can you raise your right hand for me, please?
Yes, ma'am.
You do solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right.
Your Honor, in the
Yeah, he's coming.
to be
We got
efficient.
him. Two people are coming by 11:30.
Your Honor, I was going to ask for the purpose of efficiency, I don't mind going forward if they're not physically present, as long as the clients don't mind being over the jail feed. because I don't want to impose on the court waiting.
You've
an hour.
already had one of them coming, so that's not, once you say it,
Okay.
and they do it, it's hard to take that back. So we already got one coming.
Okay.
Now, Mr. Lamb, this could, Mr. Lamb, would you like to have a hearing now, or would you like to appear before me?
Whatever's easiest for you guys, Your Honor.
We'll do the hearing now.
For Mr. Lamb, I can do your motion for non-monetary release. Who's the state?
Yes, ma'am.
For that one, we can do your motion for non-monetary release conditions. Have Mr. Alvarez, though, come over. That's a little bit different. I'm sure he wants to be present for that one. Or I can ask him. I think it's in the best to just let that kind of motion. No worries. We can bring Mr. Alvarez here. All right, Mr. Warren, we're going to have your hearing now. Is there anybody left, though, before we have his hearing that we can do? Is there anybody left in there, Deputy? All right, so yeah, we'll go ahead and start his hearing. Or we can clear, what is this, a driving license? Yeah, we can go ahead and do this one now. All right, counsel, your motion.
Thank you, Your Honor. Mr. Lamb was arrested on September 7th, 2021. He is charged with.
Okay, give me one moment.
Yes.
One moment, ma'am. Belkis. Look, sorry. Somebody asked my lawyer's name. They got the same lawyer, so I apologize.
Are you ready for your hearing, sir?
Yes, ma'am, I am.
Okay. That means eyes front, paying attention, your life, your case. All right.
Sorry.
No worries, it's your case. Motion for non-monetary release and conditions, counsel.
Your Honor, Mr. Lamb was arrested on September 7th, 2021. He is charged with count 1, driving while license revoked as a habitual offender. And currently, as the court may see, he is confined at the Osceola County Jail with a bond set at $2,500. May I elicit testimony from Mr. Lamb?
You may.
Mr. Lamb, can you afford the $2,500 bond?
No, ma'am, not at the moment.
If you were to be released, would you have a place of employment?
Yes, ma'am.
I see that.
Where would you work?
I would more than likely go back to work for the company I work for, JCB. We work out at Disney, reconstructing Epcot, ma'am, Project Gamma.
Do you have a place to stay?
I'll be staying with one of my coworkers in
number 7.
the motel up there. It's the Econo. I'm not sure what room he's in now because they move you weekly.
And Mr. Lamb, is that located in Kissimmee?
Yes, ma'am, it is.
Okay. If you are released, would you leave the jurisdiction of the court?
I don't understand the question, ma'am.
If you were to be released, do you promise to appear for all future court hearings?
Oh, yes, ma'am.
And if a change of address occurs, would you inform the court?
Yes, ma'am.
Your Honor, at this time, I have no further questions.
I see that he's currently out on direct PTR already on a case 21MM1947 for trespassing in a structure of conveyance. Is that still?
No, ma'am.
1 minute.
Your Honor,
You
1
see that?
second.
1947, Your Honor. I see 21MM1947. He is currently on direct PTR already for trespassing in structure or a conveyance.
I show defendant pled guilty on September 15, 2021, took 60 days in the Osceola County Jail with 62 days credit for time served.
Perfect. And that was September
15th, Your Honor.
All right.
Your Honor, no further questions for Mr. Lamb.
I have no questions for the defendant, Your Honor.
All right, so I'm going to, based on him no longer pleading out on September the 15th, 21MM1947, he did not qualify for PTR because he was already on direct PTR. I think he probably will qualify for direct PTR at this time. So the court's going to enter direct PTR at this time. If he does not qualify for direct PTR, then I will release him on a non-monetary bond.
Thank you, Your Honor.
Thank you. All right, Mr. Warren, so, it's all right, I'm confused. So, Mr. Warren, at this time, what's going to happen is you're going to be released to pretrial release, the same pretrial release that you released to and your 21MM1947 case, you're going to release back to them in this case. All right? There is no monetary bond, but you're going to have to check in with the pretrial release service.
So I leave today.
I don't know that you are in our order. I'm going to give you to direct PTR. And then from there, they will administer your release.
Yes, ma'am. Thank you.
Thank you. Have a great rest of your day. I do want to put some conditions. Hold on. Special conditions of, let's go back. Let's go ahead and add these special conditions of release really quick. So you have some special conditions. No driving without a valid driver's license, okay?
Yes, ma'am.
All right. Good luck, sir.
Thank you. Thank you, Ms. Belkins.
You're welcome, Mr. Lamb.
All right. That was the special conditions of releases for PTO. If he doesn't qualify, then I'm just going to do an ROR so that he doesn't have to come back. We don't have to do all coming back.
Excuse me, Your Honor.
Yep.
Michael Hernandez Rivera wants to know if he can have his hearing at this time. Hector
second.
Alvarez, I'm sorry, Hector Alvarez.
Hector Alvarez, if the court would like to proceed, Your Honor, I'm ready. It's the motion for reduction of bail.
If that's what he wants.
Thank you.
Make it easier on you guys. Nobody wants to go home.
I don't know what you just said, sir. What'd you say?
I said I just would like to make it easier on you guys and, save the time to travel over there.
It's your case and your life. It's not our life and it's not our case. So it's whatever you would like to do, sir.
Thank you, ma'am. Appreciate it.
All right. Counsel? So just for the record, we have offered Mr. Hector Alvarez Jr. an opportunity to come into the court. We have arranged that transportation. At this time, Mr. Hector Alvarez Jr. has declined to come into the court and would like to proceed with his motion for reduction of bond inside of the Osceola Corrections Facility. Is that correct, Mr. Alvarez?
Yes, ma'am. That is correct.
Counsel.
Your Honor, Balkis Izquierdo on behalf of Mr. Alvarez, on October 6, 2021, Mr. Alvarez was arrested for count 1, grand theft. The case at this time remains unfiled. The bond is set at $2,000. Mr. Alvarez has remained in custody for 14 days. At this time, may I elicit testimony from Mr. Alvarez?
Yes.
Mr. Alvarez, can you afford the $2,000 bond?
No, ma'am.
How much can you afford?
Right now, I can't get to any money whatsoever. I would ask the court if they can please ROR me or release me with some conditional pretrial release if possible, but at least any reduction will be fair and I'll try my best to bond out.
Is there any monetary amount that you can afford?
Possibly $100. I could possibly try to get a hold of somebody for $100, yeah, with a 10%.
If you were to be released, do you have a place of employment?
Oh, yes, of course. I work landscaping for Terracon Services.
If you were to be released, do you have a place to stay?
Yes, ma'am, I do. I live at 5451 Byland Road, apartment 2306, Orlando, Florida, 32811.
Thank you, Mr. Alvarez. Your Honor, no further questions.
Mr. Alvarez, do you know anybody or have any reason to be at the Saralago Hotel located at 5678 West Earlo Bronson Memorial Highway?
Oh, no, ma'am, I will never return there.
Okay. State has no further questions.
I have a lot of questions. Where do you have a savings account, sir?
No, ma'am, I have a checkings account.
And how much money is in your checking account?
It's probably just a few dollars right now.
Who do you live with?
With the mother of my child and my 2 children.
She work?
She's working weekends now. She just started.
And how much money do you think that she would be able to give you for your bond?
Possibly the $100.
Do you own a home?
No, ma'am, I rent.
How much is your rent?
$1,300.
How do you afford $1,300 in rent?
Father-in-law is helping us, and I work for Terracon Services.
Do you think your father-in-law will be able to help you and assist you with the bond?
I don't think so.
Do we have a score sheet? All right, passed up. Thank you. Trying to find a reason for reduction of bond here. I have to have. Let's see. Do you own a vehicle?
No, ma'am.
How do you get to work?
I bus.
How do you pay for the bus?
With what I get paid with at my job.
What do you make an hour?
$15 an hour.
$15 an hour?
Yes, ma'am.
How many hours do you work?
Roughly sometimes the whole 40.
What's your schedule?
From 9 to 6.
Monday through Friday?
Yes, ma'am. Usually they always cut us early, it rains or whatnot, but
And what, you work landscaping? Do you own any tools?
no, ma'am.
Let's see here. Do we recover any of the property?
He abandoned the property when the owner of the property came out and confronted him at that hotel location.
Thank you.
And I don't see contact with the victim being, the victim's out of state.
Right. Court's gonna grant, let me see, give me a minute. I haven't really heard, let me see something. Who pays for all the bills at your house?
Between me and my father-in-law, he stays with us for the most part.
So your father-in-law contributes?
Yes, for the most, like, yeah, he pays everything almost.
So then you would have some available money if your father-in-law is contributing to everything?
Basically, now he's paying everything too. Now that I'm arrested, he's taking over everything.
Okay. So I hear that we have somebody who has an ability to help. So give me one moment. Purpose of a bail determination in criminal proceedings is to ensure the appearance of the criminal defendant at subsequent proceedings, to protect the community against unreasonable danger. The nature and the circumstance of this offense is the grand theft. It looks like from the items were abandoned. Based on the score sheet, previous convictions, looks like misdemeanors. There was a felony and trespass in the structure, something similar. I don't see any failure to appear. Give me one moment, sir. But I do see the same grand theft, third-degree charge again in 2019. At this time, the court, based on the nature and the probability of the danger the defendant releases to the community, I do think it's low based on the victim being out of state. The source of funds used to post bail, I've heard that he has some ability to have some help with his father-in-law. In fact, the father-in-law is paying all of the bills at this time. I'm going to reduce the bond from $2,000 to $1,000. Following conditions, special conditions and they're still going to be bond with PTR, so it's still PTR. Now it's just $1,000. No contact with the victims, no return to the scene. Good luck, sir.
You're welcome. Thank you, Lucas. Thank you, Your Honor.
Thank you, Mr. Alvarez. Thank you, Your Honor.
Thank you.
Do you need me to put locations on record for Madam Clerk, ma'am?
Please.
The location no return to is 5678 West Earlo Bronson Memorial Highway. That's the Sarah-Lago Hotel. The no contact is with Peter Timkey, Timkey.
Good afternoon. I'm Judge Netcher. I'll be handling initial appearances today. There we go. Good afternoon. We're going to replay. Sorry, we weren't on the record yet. I'm Judge Netcher. We'll be handling initial appearances today. Could counsel please state your appearance, starting with the state?
Yes, Your Honor. Alex Card for the state.
And the defendant? And the PD's office?
Christina Smith for the PD's office.
Okay. And pretrial release?
Yes, Your Honor. Officer Pat Hill on behalf of PTR.
Okay. Ms. Smith, I'd ask if there's any probable cause challenges to state them at the outset.
Yes, Your Honor.
Not currently, but as the cases are called.
Yes, Your Honor.
All right, we'll start with the Spanish interpreter cases.
Good afternoon, Your Honor. This is Teodoro Leal, Spanish interpreter. The interpreter has been previously sworn, Your Honor.
Good afternoon. This is Judge Netcher here for initial appearances. And the first case we have is Mr. Abril Ortiz, or Emmanuel Abril Ortiz.
¿Me escucha?
And if you could, and this goes for everyone, please state your name and date of birth when you approach the microphone.
Y un anuncio para todos los que van a venir al micrófono, van a dar su nombre, apellido y su fecha de nacimiento, por favor.
The microphone is off.
Está apagado el micrófono.
We're still not getting that in here.
Very, very faint.
There's a button on the microphone in front of him.
I believe there may be a button on the microphone in front of Mr. Abril Ortiz.
The interpreter could barely hear, but pretty sure he said September 18. ¿Qué año? 1996. Yeah, the microphone is not working that well.
Mr. Abril Ortiz, I'm going to appoint the public defender to represent you in this case.
Señor Ortiz, voy a designar al defensor público para que lo represente a usted en esta causa.
You have been charged with battery, touching, or striking.
A usted se le ha interpuesto una acusación de agresión física, tocando o golpeando.
Domestic in nature.
De tipo de violencia intrafamiliar.
I've reviewed the charging affidavit and find that there is probable cause for the charge.
He revisado el escrito acusatorio y determino que hay indicios de culpabilidad en este cargo.
I am setting bond at $5,000.
Estoy fijando una fianza de $5,000.
You are to have no contact with the victim.
Se le prohíbe el contacto con la víctima.
You are to maintain separate residences and not return to the scene of the alleged crime.
Tiene que mantener residencias por separados y se le prohíbe volver al lugar del presunto delito.
You are not to possess weapons or firearms.
Se le prohíbe la tenencia de armas, incluyendo armas de fuego.
And you shall relinquish any weapons or firearms that you do have to appropriate law enforcement.
Y si tiene algún tipo de arma de fuego, tiene que entregarlas al departamento de policía apropiado.
Okay.
Your Honor, will that be within 24 hours of his release?
A las 24 horas de su liberación. Sí, a las 24 horas de su liberación.
And Your Honor, I apologize, I may have just missed it. Did you announce no contact with the victim in the case?
I did.
Thank you, that's all.
I'm sorry, Your Honor. Mr. Ortiz, case number, please.
Oh, yeah. 21MM2840.
Thank you, Your Honor.
Your Honor, we'd ask for a one-time return for him to collect his belongings, please.
Pedimos que vuelva una vez al lugar para que pueda recoger sus pertenencias.
You will be allowed to return one time with law enforcement to recover any belongings you have.
Se le va a permitir volver una sola vez en compañía de las autoridades para que recoja sus efectos personales.
Okay, thank you.
Okay, gracias.
You may sit down.
Puede sentarse.
Reporting just called me and they said that the SO turned off the microphone. It was on, but now it's off, so he needs to touch that button again.
Okay. If we could have apparently the microphone has been turned off. If it could be turned back on, that would be great.
Is it on, Your Honor?
Yes, thank you.
Yes.
Okay, Pablo Laporte Fonseca.
Your Honor, there's going to be a probable cause argument on this one.
Okay. Could you please state your name and date of birth?
Nombre, apellido y fecha de nacimiento.
Pablo Laporte, abril 17 del 85.
Pablo Laporte, April 17 of 1995.
Okay. I am appointing the public defender to represent you.
Estoy designando al defensor público para que lo represente en su causa.
Let's hear the probable cause challenge, Ms. Smith.
Escucharemos a la señora Smith, que tiene un argumento de indicio de culpa.
Your Honor, regarding the first count, aggravated assault with a deadly weapon, there appears to be no apparent availability, no well-founded fear, and there was no apparent weapon within the affidavit.
Su señoría, es en referencia al caso de amenaza agravada con un arma mortífera. Realmente no existe tal capacidad para tal cosa, no hay ningún peligro de temor inminente y tampoco se encontró que hubiese algún arma en absoluto.
State would agree to count one. We would just argue that there is probable cause for count two, the simple battery.
Sí, estamos de acuerdo de eso en el cargo número 1, pero sí determinamos indicio de culpabilidad en el segundo cargo, que fue una agresión simple.
Okay. I am finding that there is not probable cause for count 1 with aggravated assault with a deadly weapon. I am finding probable cause with respect to count 2 of battery, simple touching or striking. Mr. Laporte Fonseca qualifies for pretrial release, and we will set bond at $1,000. You are not to have any weapons. Oh, excuse me. Mr. Interpreter, would you like to?
Thank you, Your Honor. Entonces el tribunal ha determinado que en el primer cargo de arma mortífera, con amenaza de arma mortífera, no hay tal indicio de culpabilidad. Sí se determina que hay indicio de culpa en el segundo cargo, que es el de agresión simple, que es tocar o golpear a alguien. En cuanto a la calificación, el señor Laporte sí califica para que se le dé libertad provisional. Tendría que pagar una fianza por la cantidad de $1,000. Your Honor, the interpreter went as far as $1,000 bond, and something about contact, that part, the interpreter missed it.
Okay, so we're going to set a $1,000 bond with PTR conditions.
Eso tendrá condiciones de libertad provisional y se le entregará la fianza de $1,000.
You are to have no contact with the victim.
No deberá tener contacto con la víctima.
You are not to have any weapons or firearms.
Se le prohíbe el uso o porte de armas de fuego, incluyendo armas de fuego.
And you shall relinquish any weapons or firearms to law enforcement within 24 hours.
Y tiene un periodo de 24 horas para entregar cualquier arma que tenga a las autoridades.
State, do you need or are you requesting more time with respect to count 1?
¿Necesita más tiempo para el cargo número 1, fiscal?
Yes, Your Honor. Just out of an abundance of caution, the state would request a 24-hour reset on count 1 just to see if there's any additional information from the deputy that investigated the case.
Sí, su señoría, simplemente para que seamos prudentes, a ver si podemos dejar el caso del cargo número 1 para darnos tiempo a que tengamos más información del policía que está trabajando en el caso, a ver si tiene algo más que agregar.
Defense, what do you say about that?
¿Qué dice usted al respecto, licenciada de la defensa?
Defense would still ask for RORs to count 1 and then for a one-time return as part of the conditions for count 2.
Y Pues todavía pedimos entonces, la defensa todavía pide entonces que se le dé en ese cargo libertad bajo palabra y que se le conceda permiso para volver al lugar a recoger sus cosas una vez.
I'm going to allow a one-time return under the supervision of law enforcement with respect to count 1, or excuse me, with respect to count 2. With respect to count 1, I'm going to ROR. If the state has additional information, they can direct file.
Yes, Your Honor.
Sí, entonces en cuanto al primer cargo, lo que voy a hacer es que voy a concederle la libertad bajo palabra. También voy a permitirle que regrese, en cuanto al cargo 2, que regrese en compañía de las autoridades a recoger aspectos personales. Y si acaso la fiscalía tiene algo más que agregar, la fiscalía podrá más adelante interponer una causa.
Okay, you can sit down, Mr. Laporte Fonseca.
Señor Laporte Fonseca, ya puede sentarse.
Veronica Rivera Estrada.
If the interpreter could have Mr. Laporte's case number, please.
I got a personnel side, Your Honor.
It's 21 CF 3121 for Laporte. Fonseca.
Thank you.
I have, for the last one.
Nombre, apellido y fecha de nacimiento.
Verónica Rivera, septiembre 10 del 1982.
Perdón, ¿septiembre qué?
10 del 1982.
Gracias, Verónica Rivera, September 10th of 1982.
Ms. Rivera Estrada, I'm going to appoint the public defender to represent you.
Okay, thank you, sir.
Señor Rivera Estrada, voy a designar al defensor público para que la represente en su causa.
I've reviewed the charging affidavit and find that there is probable cause for the charge.
Ya yo revisé el escrito acusatorio y determino que hay indicios de culpa en este cargo.
I am ordering pretrial release, bond with pretrial release PTR conditions.
Entonces voy a conceder una fianza con libertad provisional, con condiciones de libertad provisional.
And we have an individual present. Can you state your name?
Yeah, Robert Oliveira.
Tenemos a Robert Olivera, un individuo aquí presente.
Okay, I don't want to hear about exactly what happened, but let me ask, are you in fear? Do you have any fear of Ms. Rivera Estrada?
No, Your Honor.
No quiero que se me diga nada de lo que pasó, pero ¿tiene usted temor a la señora Verónica Rivera Estrada? No, su señoría.
Would you be hesitant at all if there is another incident to contact law enforcement?
¿Y si hay algún otro incidente, usted
I don't think anything further will happen. I think, yeah. Sorry.
Just give the chance for the interpreter to interpret.
Oh, okay. I don't think anything else would happen. I think she'll be fine now.
And
¿Dudaría usted de contactar a la fuerza pública si pasara así? No, yo realmente no creo que nada así va a suceder en el futuro. Ella va a estar bien de ahora en adelante.
are you requesting that you be allowed to contact, or that Ms. Rivera Estrada be allowed to contact you?
Yes,
Yo pedí entonces
please, Your
que
Honor.
permitir que la señora Rivera Estrada pueda estar en contacto con usted. Por favor, sí, su señoría.
Okay. I'm going to order set bond at $500 with pretrial conditions. Ms. Rivera Estrada, you are to have no alcohol, and that is subject to random urinalysis.
Se va a conceder, señora Rivera Estrada, la fianza de $500 con la libertad provisional. Se le va a prohibir el consumo de alcohol, y también se le dará análisis de orina al azar.
You are to have no hostile contact with the alleged victims.
No puede tener contacto con ningún tipo de hostilidades en contra de la presunta víctima.
That means if you are in an argument and you yell, raise your voice, have any sort of contact with the alleged victims that could be considered hostile, there's a chance you may be considered to be in violation of your bond, and you may be brought back to jail.
Entonces, esto lo que quiere decir la explicación es que si tienen un contacto donde hay gritos o hay ese tipo de asperezas y hostilidades, es muy probable de que usted sea hallada en desacato, se le revoque la fianza y vuelva otra vez aquí a la cárcel.
You are to possess no weapons or firearms.
Se le prohíbe el uso y porte de armas, incluyendo armas de fuego.
And relinquish any weapons or firearms that you may have.
Y entregue cualquier arma de fuego o tipo de arma que usted tenga en su poder.
Okay, you may sit down, Mr. Rivera Estrada.
Puede sentarse, señor Rivera Estrada.
Thank you, sir.
Thank you, Your Honor. I appreciate it.
Madeline Santini.
President approaching, Your Honor.
We have two witnesses out here, Your Honor.
Your Honor, could you perhaps Mr. Rivera Estrada's case number, please?
That's 21 MM2846.
Thank you, Your Honor.
45, Judge.
Oh, for this one or the last one?
For the last one, he said.
Okay.
I got it.
Yeah.
21 MN 2845.
Thank you.
For Santini is 21 MM 2846.
Thank you. Nombre, apellido y fecha de nacimiento.
Martinez Santini, May 12, 1990.
I would ask, we typically don't allow children in the courtroom for these proceedings. If they could be removed, we could call one of you back if you can take turns watching the child. Miss Santini, you've been charged with battery, touching or striking, domestic in nature.
Señora Santini, a usted se le acusa de agresión física, tocar, golpear, de violencia intrafamiliar.
I find that there is probable cause for the charge.
Es determinado que hay indicios de culpabilidad en este cargo.
And we have, could you state your name, sir?
My name is Jason Lopez. The reason I'm here, to be honest.
Just a moment. I don't want you to talk about the incident or what happened. We're here to talk about conditions of release.
Yeah, it wasn't even no accident. The reason I'm here, I don't even know why she's in jail.
Okay.
I didn't write a statement against her.
Just a moment. We're just here to determine. We're just here to determine conditions of release, and go ahead, interpreter.
Thank you. No, es que aquí nada más estamos para determinar cuáles son o cuáles van a ser las condiciones de su liberación. No tiene que hablar de los detalles del incidente ni nada de eso.
And let me ask you, Mr. Lopez, or do you have any fear of Madeline Santini?
No.
Le pregunta, señor López, ¿le tiene temor a la señora Madeline Santini? No, no le tengo temor.
Are you concerned that she could pose a threat to you or anybody else in your family?
¿Usted piensa que ella,
no.
ella lo consideraría que ella es una amenaza para usted o algún otro miembro de la familia? No.
Are you requesting that Miss Santini be allowed to have contact with you?
She should be released. That's what I should say.
Pide que la señora Santini tenga contacto con usted, su señoría.
I'm not in danger. I'll explain to the officer what happened. All she did was elbow me.
I appreciate that.
That's all.
Okay. If we could bring in the other individual.
Yeah.
Simplemente yo le explico al oficial lo que ha pasado, era simplemente de un codazo, pero no siento que ella sea ni una amenaza ni ningún tipo de peligro para mí.
Hi, ma'am. Could you state your name?
My name is Kristen Trinidad.
And Ms. Trinidad, do you have any fear of Miss Santini?
I do
¿Le tiene temor a la señora Santini? No le tengo miedo.
Do you live with Ms. Santini?
¿Vive con la señora
She
Santini?
lives downstairs from me.
Vive en el piso de abajo.
Are you concerned that Ms. Santini poses a threat to you or to other individuals in her family or friends?
No, the one that poses threat here is Jason.
I don't need to hear about that. We're here with respect to Ms. Santini.
¿Y usted cree que la señora Santini constituya una amenaza para usted, para otra persona, para otro miembro de la familia? No.
Thank you.
Gracias.
Okay, I'm going to impose bond of $500 with PTR conditions.
Así que voy a conceder una fianza de $500 con condiciones de libertad provisional.
You are to have no contact with the alleged victim, Mr. Lopez.
Se le prohibirá el contacto con la presunta víctima, el señor López.
I understand that, well, I don't think they're living together. Anything further?
¿Algo más?
Defense?
Defensa.
Your Honor, we'd asked for no hostile contact with Mr. Lopez. It sounded like he indicated that he was not afraid of the return of Ms. Santini at this time.
Sí, vamos a pedir, su señoría, a ver si le puede conceder contacto con el señor López, a la señora Santini, que haga contacto sin hostilidad. Parece que él no estaba temeroso ni preocupado, no le tenía temor a la señora Santini.
State.
Fiscal.
State would ask for no contact at this time because of how fresh the incident is. And that's all from the state.
Y la fiscalía va a pedir que no haya ningún tipo de contacto debido a la reciente naturaleza de los hechos. Eso es todo lo que quiere la fiscalía.
Yeah. I'll award no hostile contact.
Ordenaré contacto sin hostilidad.
Thank you.
Gracias.
You may sit down.
Puede sentarse.
Thank you, sir.
So she will get released or bail? Or?
You can speak with the... Thank you. Could we ask if there are anybody else that needs a Spanish interpreter?
¿Alguien más requiere los servicios del intérprete de español?
Yes, Your Honor.
Okay.
There's two, Your Honor.
Okay. Who's the first one?
Okay, the first is President Percy.
Nombre, apellido, fecha de nacimiento.
Mr. Figueroa Rivera. And the other, it will take a moment, he's back in the cage.
Okay, Mr. Figueroa Rivera, you have been charged with battery, touching, or striking, domestic in nature.
Señor Figueroa Rivera, a usted se le imputa por un cargo de agresión física, de tipo de violencia intrafamiliar.
I am appointing the public defender to represent you.
Estoy designando al defensor público para que le represente.
I have reviewed the charging affidavit and you've been charged with battery, touching, or striking, and tampering.
Y a ti se le está acusando de tocar o golpear, el caso de agresión física, y también se le agregó el caso de interferir.
I've reviewed the charging affidavit and find probable cause on both counts.
Ya yo revisé el escrito acusatorio y determino que hay indicios de culpabilidad en ambos cargos.
I am setting bond at $1,000 for each count, total of $2,000.
Le estoy otorgando una fianza de $1,000 por cada cargo, con un total de $2,000 de fianza.
You are to not consume any drugs or alcohol, and that's subject to random urinalysis.
Y se le prohíbe el uso de alcohol o de drogas y estará sujeto a exámenes antidrogas al azar.
You are to have no contact with the alleged victim.
Se le prohíbe el contacto con la presunta víctima.
Your Honor,
Yes.
if I may, he does not at this time qualify for PTR, so there's no, nobody that can monitor random drug and alcohol testing?
Okay.
Él no califica para libertad provisional, así que no hay nadie que pueda estarle monitoreando el consumo de alcohol o de drogas para hacer las pruebas.
I will not order that.
Entonces no lo voy a ordenar.
Anything further?
¿Algo más?
At this time, defense would ask for a one-time return with law enforcement.
A esta altura la defensa pide que vuelva una vez al lugar en compañía de las autoridades.
I will allow a one-time return under the supervision of law enforcement to recover any belongings, Mr. Figueroa Rivera.
Así que voy a permitir que el señor Figueroa Rivera pueda volver una vez al lugar con la compañía o el monitoreo de un oficial de la fuerza pública para que pueda recoger sus pertenencias.
Thank you. You can sit down.
Gracias, puede sentarse.
And who was the other individual that needed an interpreter?
Is it President approaching, coming back from the cage, though, Your Honor?
Thank you.
It's Carry on Medina, Your Honor.
Mr. Medina, you are here on an out-of-county warrant in Orange County.
Señor Medina, usted está aquí porque lo están solicitando otro condado, el condado de Orange.
The warrant was for failure to appear.
La orden de arresto está relacionada con una inasistencia a una cita judicial.
Bond was set at no bond, where it will remain.
Se queda sin fianza.
You may be seated.
Puede sentarse. I'm sorry, Mr. or Madam Clerk, Mr. Carrions Medina, case number, please.
I'm sorry. You know.
Yeah, it's usually, it's right here, 21 CF 1563.
70. It's 21 CF 156370.
Thank you, Your Honor.
Okay, anybody else that needs an interpreter?
¿Alguien más que necesite intérprete?
No, Your Honor.
Okay, great. Thank you very much, Mr. Interpreter.
You're quite welcome, Your Honor.
Okay. Justin Mann.
President approaching, Your Honor.
Justin Mann, 52381.
Mr. Mann, you are here under 3 warrants for violation of probation. There will be no bond.
Hey, I got a question. I'm out on bond right now for a case in Osceola County. It's a driving case. Could you revoke that?
I'm not here to do that today.
Thank you.
All right. Frank O'Donnell?
He bonded.
He bonded, okay.
Well, somebody posted his bond. I was just,
His bond has been processed, Your Honor. They're just in the process of bonding him out.
Okay, you can sit down. Hernandez Tillman?
Hernandez Tillman, 92579.
Mr. Tillman, you are here on 2 warrants for violation of probation and failure to appear. The bond on the failure to appear is set at $500 for possession of cocaine, and the bond on the violation of probation is set at, they're both.
No, they're both.
They're both violation of probation.
VOP for possession is failure to appear for possession is the $500. VOP driving while license suspended.
Yeah, the bond for failure to appear is set at $500. The bond for violation of probation for driving while license suspended is $2,500. Thank you. Rihanna Hurd.
Rihanna Hurd, 11/16/92.
You are here on a warrant for battery, touching or striking, domestic in nature.
Yes.
Probable cause was previously found. I'm setting bond at $1,000. You are to have no weapons or firearms and relinquish any weapons or firearms that you may have. And you are to have no hostile contact with the alleged victim.
Yes, sir.
Okay?
Your Honor, is that with PTR?
Yes, with PTR. Thank you. You may sit down. Keith Johnson.
Your Honor, he's present and approaching. He's coming from the cage, though. We would also at this time request a waiver of reading of charges.
Thank you.
Keith Johnson, 042594.
Okay. Under the charge, there is no bond. Excuse me, I'll appoint the PD to represent you. There is no bond. And we have a person present. Could you state your name?
Lakiriana Davis.
Okay. I don't want to hear about the incident or what's been alleged, but what is it that you would like to say today?
Oh, well, if you don't want to hear about the incident, because I was present at the time of the alleged incident, so.
Okay, well, we're not here to determine that. To the extent that Mr. Johnson will seek bond, he can file a motion that can be heard with the presiding trial judge. Anything further from the state on this?
Nothing further from the state.
From the defense?
Nothing further from the defense.
And who is his public defense?
And I'll also order no contact with the alleged victim. Thank you. Thank you, ma'am.
I was just asking, who is his public defense?
The public defender has been appointed.
Okay.
Kareem Reed.
President approaching, Your Honor.
Reed, 1992. Well, February 17, 1992.
Mr. Reed, you're here on a bench warrant that was issued for the failure to appear. There is no bond.
Thank you.
John Vasquez.
President approaching, Your Honor.
John Vasquez, 10-4-1986.
Mr. Vasquez, you're here for violation of probation, case number 20 CF 3443. There is no bond.
He has two cases, Judge.
He's got two. Just a moment, Mr. Vasquez. Let's see. Oh. Yeah. You're also here, Mr. Vasquez, for violation of probation in case number 20 CF 3461. There is no bond.
Yes, Your Honor.
Angelique Hazley.
President approaching, Your Honor.
That's the carpet.
State, is this a new charge?
It's a warrant, Your Honor. She's currently in custody on other charges, and she's been in custody for a while. I don't have her actual intake date, but these are added charges to those.
What is the added charge?
Well, the added charge is the petty theft. She's currently in custody on drug charges. She's been in custody since October 9th of this year on the drug charges.
And Your Honor, I'm not sure if this helps as a point of clarification, but it looks like the incident date was back in September of 2021, but there was a direct information filed by the state in October of 2021. So maybe that's why it appears to be new, is because it looks like the direct information that was filed was rather recent.
Thank you. Ms. Hazley, I will appoint the public defender to represent you. You are here on a warrant for petty theft, third or subsequent offense. There is probable cause for the charge. I'm setting bond at $1,000. I don't need to order no return if she's not getting out. And no return to the scene of the alleged incident. Thank you. Brittany Austin.
Austin, 1988.
Miss Austin, you have been charged with child neglect without great bodily harm and culpable negligence. I will appoint the public defender to represent you. I've reviewed the charging affidavit and find probable cause on both counts. I am setting a bond of $2,000 on the first count, child neglect, and $500 on the second count, culpable negligence. You are to have no hostile contact with the alleged victim, meaning that there can be no, if you get into an argument with the alleged victim, or if there are anything related to what is alleged in the charging affidavit that could remotely implicate harmful contact with the alleged victim, you could come back in violation of your bond. She does not qualify for PTR.
That's correct, Your Honor.
Yes, sir. I'll tell you what, since we just have one person, Miss Gurley, could you bring her up? Miss Gurley? Good morning, Miss Gurley.
Good morning.
This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you. You have one count of driving a vehicle on a suspended license. To advise you of certain rights, you have the right to the presumption of innocence, the right to indictment by a grand jury, or by accusation in this case, because this is a misdemeanor, the right to a speedy and public trial by jury, the right to see, hear, and question witnesses who are called to testify against you, the right to compel the attendance of witnesses to testify on your behalf, the right to testify on your own behalf or offer evidence in your own defense, and the right to have an attorney represent you. I'll get with you in 1 second, Deputy Requena. You're going to have a preliminary hearing date, ma'am, that's going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor, please.
Are you currently working, ma'am?
Yes, sir.
About how much do you make per hour?
$17.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor.
Okay, ma'am, you're free to go back.
Okay, thank you.
You're welcome. All right. Because it was taking so long for you to connect and I only had one lady, I decided to go ahead and deal with her.
I was just pulling one that wasn't here. You still need last name Porter to appear for first appearance today?
Porter? Is that the person that was hearing impaired?
I'm not too sure. He said he did first appearance yesterday, and he's still on the list for today.
Oh.
Last name Porter, first name Ivan.
I don't see him on my list. He's been struck through on the list that I received from the jail, and I don't have his information here. So I would presume that he has already gone through first appearance.
Okay. All right. I'll just send it back.
Okay. Thank you. Thank you. Is it Deputy Jackson? Thank you. Have a good day.
Yes, Your Honor. You as well. Thank you.
All right. Let's switch over to the male side. Okay. Good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Lastly, I need everyone to raise your right hand for me, please. Do you swear or affirm that any statements you make during this proceeding will be the truth, the whole truth, so help you God? Okay, let's begin with Mr. Is it Elice?
Yeah. Yes, it is.
Okay, Mr. Elice, you've been charged with one count of driving under influence of alcohol to the extent that you were a less safe driver. Bond is going to be set at $5,000 for that charge. 1 count of possession of marijuana less than an ounce, bond is set at $1,500, and 1 count of use or possession of drug-related objects, bond is also set at $1,500. So that's a total bond of $8,000. Do you believe you can post that bond, sir?
Yeah, that's gonna be 10%, right?
Yes, sir.
Okay.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
Are you currently working, sir?
Yes, I am.
About how much do you make per hour or per month?
$19 an hour.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, sir, you're free to go back.
Okay. Thank you.
You're welcome. Mr. Ballian.
Yeah.
Sir, you appeared before me back in June.
Yeah, it's the same situation. My brother said.
Okay, so you're charged now with 1 count of aggravated assault. Bond is going to be denied at this point. There's going to be a stay away provision on the bond to stay away from a Cormasa Ballian. Do you understand that?
I almost know what you said. Come again.
I'm sorry, sir.
You said what? I almost know what you said just now.
I can't understand. I can't.
You're not gonna get a bond?
No. You're already on bond and you've been arrested on an aggravated assault charge with the allegation of choking your mother. Okay, so you're not going to get bond at this point. Your case has been transferred over to Superior Court from when you were arrested back in June. You're going to have a preliminary hearing date set for December 6th at 8:30 in the morning, courtroom 201. And you're going to have a bond hearing date set for December 10th at 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working?
Yes.
About how much do you make per hour?
$15.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Okay, sir, you're free to go back.
Thank you.
Mr. Burns. Mr. Burns, so you're charged with 1 count of obstructing an officer as a misdemeanor. The bond is going to be set at $2,000. 1 count of simple assault. Bond is also going to be set at $2,000. And 1 count of a pedestrian in the roadway under the influence. Bond is going to be set at $1,000. So that's a total bond of $5,000. Do you believe you can post that bond?
Yeah.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working, sir?
No.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Cook.
Fine.
Are you Mr. Cook?
Yes, sir.
Sir, you're charged with 1 count of criminal trespass. Bond is going to be set at $1,500. Do you believe you can post that bond?
I don't.
Okay. Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to post a bond. Would you like for me to see if you qualify for the appointment of a lawyer?
Sure.
Are you currently working, sir?
I was supposed to start a job. No.
I'm going to find you qualified, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Can somebody else post my bond?
Yes.
All right, that's fine.
Okay, sir, you're free to go back.
All right.
Mr. Fitzpatrick. Sir, you're charged with one count of following too close. Bond is going to be set at $500. One count of driving under the influence of alcohol to the extent it made you a less safe driver. Bond is going to be set at $5,000. And one count of driving a vehicle without a valid license. Bond is going to be set at $1,000. Your total bond is going to be set at $6,500. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for December 27th. I'm sorry, December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
Yes, sir.
About how much do you make per hour?
About $11.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back.
Thank you.
Mr. Flanagan, you're welcome.
Good morning, Your Honor.
Good morning. Sir, you're charged with one count of simple assault. Bond is going to be set at $2,000 and one count of criminal trespass. Bond is going to be set at $3,000. That's a total bond of $5,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond to stay away from a Tasha Smith. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
Yes, sir.
About how much do you make per hour?
$18.50.
Okay, you do qualify, sir. Going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Freeman, you're welcome. Mr. Freeman, sir, you're charged with one count of criminal trespass. Bond is going to be set at $3,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. There's going to be a stay away provision on this bond to stay away from it looks like a Setiraya, Setyriih Harrison. Do you understand that?
Yes, sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
Yes, sir.
About how much do you make per hour?
17.
Okay, sir, you do qualify. I'm going to appoint a lawyer to represent you. You're free to go back.
Appreciate it.
Mr. Hill. Mr. Hill, sir, you're charged with one count of battery. Bond is going to be set at $5,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on this bond to stay away from a Nicole McCamey. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, Mr. Hill?
Yes, sir.
About how much do you make per hour?
$16.25.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, sir, you're free to go back. Mr. Knox. Mr. Knox, sir, you're charged with one count of criminal trespass. Bond is going to be set at $3,000. Do you believe you can post that bond? There's going to be a stay away provision on this bond to stay away from a Latrice Harris. Do you understand that?
Sure.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working, sir?
Yes.
About how much do you make per hour?
19.
Okay. You do qualify, Mr. Knox. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
No, sir.
Okay, you're free to go back. Let's see. Mr. McIntyre is OTB. Mr. Murphy.
Oh, sorry.
Good morning, Mr. Murphy. Sir, you're charged with one count of simple battery. Bond is going to be set at $4,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on this bond. And this name was written in two separate ways, so I'm going to pronounce both. Shanta Jada Farley or Jada Shanita Farley. It's been written both ways on the warrant. So there's going to be a stay away provision, stay away from her. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, Mr. Murphy?
Yes, sir.
About how much do you make per hour?
$12.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, sir, you're free to go back. Mr. Nelson.
Good morning, Your Honor.
Good morning, Mr. Nelson. Sir, you're charged with one count of driving under the influence of alcohol to the extent it made you a less safe driver. Bond is going to be set at $5,000. One count of speeding between 11 and 15 miles over the speed limit. Bond is going to be set at $500. One count of obstructing or hindering the display of a license plate. Bond is going to be set at $500. And one count of driving a vehicle with no insurance. Bond is going to be set at $1,000. So that's going to be a total bond of $7,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer, Mr. Nelson? Are you currently working, sir? About how much do you make per hour?
$14 an hour.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, so you're free to go back. Mr. Smith.
My pledge.
Yes.
Good morning, Your Honor.
Good morning, sir. You're charged with one count of obstructing or hindering law enforcement officer. Bond is going to be set at $2,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
I'm sorry, sir.
Yes, sir.
Are you currently working?
No, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back.
Thank you.
Now, Mr. Small, I don't know why, but Mr. Small fell in between both Mr. Smith, so I'm going to call it the way it's written. Mr. Small.
Yes, sir. Good morning, Your Honor.
Good morning, sir. You're charged with one count of criminal trespass. Bond is going to be set at $3,000. Do you believe you can post that bond?
It's possible a signature bond because it's dealing with my wife, and I don't know.
And there's going to be a stay away provision to stay away from her on this bond.
That's just kind of like I don't know about how who's gonna bum me out or not because I can't call her or none of that.
Right. So.
And I do own my own business. I mean, I do generate goodwill.
Why didn't you just open the door Well, I'm sorry. I'm not going to ask you. I'm not going to ask you that. I'm not going to ask you that question. But so, what incentive would a signature bond give for you not to do something that's alleged in this case again?
Be able to pay for me a hotel, stay savings, like get an apartment and get my things squared away.
Sir, I'm not inclined to grant you a signature bond. I'm not, because this is ridiculous. You're an adult. She's an adult.
It really is crazy.
And see, and this is a problem that people don't realize in these cases. While law enforcement is over at your house, somebody's door is getting kicked in. Somebody has a gun pointed in their face. Somebody is getting robbed. But law enforcement is over at your house playing parent to 2 children. So that's why you're not getting a signature bond.
Yes, sir.
Okay?
Yes, sir.
Your preliminary hearing date, well, there's going to be a stay away provision to stay away from Carnicia or Nicia Small. Yep. Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning. Courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. You can go through a bonding company to bond out.
Got to get my money. So right now I don't have a lot of resources. Well, I'm in here to get somebody to go and get my money, so I can do all that. So they just got to find somebody who can help me out. That's all. That's the only reason I asked for a signature bond. That's the only reason.
So the bonding company, their business model is to help people get out of jail. They will work with people. Okay. If you have a business, if you have something, they may even have you sign like a financial affidavit or a promissory note or something that they can enforce.
Okay, I thank you.
Okay. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You said you own your own business?
Yes, sir.
How much would you estimate? Well, let me ask you this. Do you pay yourself from the business, or you just take the profits from the business?
I pay myself from the business.
Okay. How much do you estimate that?
Like 12 to 15 a week.
Okay. I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Mr. Small.
Yes, sir.
Don't get yourself in stuff like this. Okay.
Very.
Okay. All right, sir. You're free to go back. Rodney Smith.
Good morning, Your Honor.
Good morning. Mr. Smith, you're charged with 1 count of criminal trespass. Bond is going to be set at $3,000. Do you believe you can post that bond?
Yes, sir, I can. But I have one question.
Hold on 1 second. Let me get through what I have to say, and then I'll let you ask whatever question you need to ask, okay? There's going to be a stay away provision on the bond, stay away from a Camille Belgrave. Mm-hmm. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
Disabled.
Okay. I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Now, what was your question, Mr. Smith?
I was going to see if I can request a signature bond since I don't have anyone to actually come to help me get out. I can afford the bond, but there's no one to, because of the person that you want to stay away, you can't use that person to bond you out.
Right. So you're in the same position as Mr. Small.
Okay.
So, again, you got to be mindful that there are people that really need law enforcement, and we can't just grab extra people because there are people at your house because of a purse allegedly being withheld and not turned back over. Do you see? If let's flip it around. Mm-hmm. You get shot, or someone is chasing you and you call 911. And guess what? Everybody's out on calls. They're at Mr. Small's house. So while you're getting chased and you the first thing, oh man, Clayton County, I called police and nobody came out. I don't know what's going on. Well, they're at your house. They're at Mr. Small's house. That's where they are for adults that are acting like children. No, sir. No, you're not getting a OR bond. Okay?
Because I mean, I can afford the bond.
I understand, but think about this. Think about why you spent the night in jail.
I did.
And so the next time that there's a dispute, don't have this be the end result. Okay? That just between adults, you would think of 16-year-olds having these issues, not adults. Okay?
Thank you.
All right, sir. Any other questions?
No, that's it.
Okay, sir. You're free to go back.
Thank you.
You're welcome. Mr. Woods.
Good morning.
Okay. Good morning, sir. You're charged with 1, 2, 3, 4, 5, 6, 7, 8 violations. And bond has been set in all of these. So the first charge is violation of Georgia seatbelt law. Bond is going to be set at $500. Second count or charge is obstructing an officer. Bond is going to be set at $2,000. The third offense is fleeing from a police officer. Bond is going to be set at $2,000. The fourth charge is reckless driving. Bond is going to be set at $2,000. Fifth charge is driving on a suspended license. Bond is going to be set at $1,500. The sixth charge is looks like driving the wrong way on a divided highway. Bond is going to be set at $500. Possession of marijuana less than an ounce. Bond is going to be set at $1,500. And what is this? It says RIP violation. And it's driving on an expired or registration or title. So your total bond is going to be set at, let's see, 6, 9, 10, $10,500. Do you believe you can post that bond?
Yes, Sean.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, sir?
No, sir.
Did you say no or yes?
No.
Okay. I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir. Actually, the driving under a suspended license and the I think it's what you said, something about some registration.
It said expired registration or title.
See, my registration actually is valid because I have a valid insurance. So I had got it reinstated online, so I'm not sure like if they didn't fix it in the system or whatnot. But I have valid insurance, so and I did that. I had to put the insurance back on the car before I could get my the registration we did.
Okay. All you have to do is show proof of that, and those charges will get dropped.
Okay, so my mama got she got the little printout. So whenever I go back to court for it, I just come present the documentation.
Yes, best thing is to make copies of that and give it to the lawyer.
Okay.
All right. Okay, so you're free to go back.
Thank you.
You're welcome. Mr. Wildy? Sir, you're charged with 1 count of criminal trespass, damage to property. Bond is going to be set at $3,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on this bond, to stay away from a Toria Green. Do you understand that?
Yes, Your Honor.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Are you currently working? About how much do you make per hour?
15.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
About, not sure. About the bond, I guess. When?
No, sir. I'm not asking you to ask me a question. If you are not sure, that means you don't have a question. Okay, you're free to go back, sir. Mr. Young? Good morning, sir. You're charged with one count of criminal trespass. Bond is going to be set at $3,000, and one count of simple battery. Bond is going to be set at $4,000. That's a total bond of $7,000. Do you believe you can post that bond?
Yes.
Okay. There's going to be a stay away provision on this bond to stay away from a Tiffany Cobbs. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for December 7th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, Mr. Young?
No, sir.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Just one. What was the bond again? You say 7,000?
Total bond was $7,000.
That was all.
Okay, sir. You're free to go back.
Thank you.
All right. So I have two fugitives from justice. One was looks like it was continued from yesterday, or maybe Saturday. Andrea Bryant. The other person is Marcus Mosley. Do you have both of them there?
Mosley is here, Your Honor.
Okay. Let's get Mr. Bryant. I don't know why it was continued over.
I don't have a Mr. Bryant here. I have Mr. Mosley here.
Yes.
Bryant.
I have, he was on my sheet as an add-on for today. His cell location looks like 7404T. Like I said, I don't have it was over the weekend. I don't have a continuous order. I don't have any understanding why a fugitive would be continued, but I'm gonna have to deal with him. So if somebody could go get him while I deal with Mr. Mosley, that'll be great. And I apologize. I intended to ask about that earlier.
So last name Brian, Your Honor, first name?
First name is Andra.
Yes, sir. Andre.
Yeah.
Right. Yes, sir.
Okay, thank you. I can't read this. I was going to try to read the LE number. It looks like a 2. It looks like it may be 2177719.
Brian, Andre. That's the fugitive from yesterday, then continue.
Can you say the LE number one more time, Your Honor?
Okay, and I can barely read the handwriting. It looks like it's 2177719.
And the last name is Bryant?
Yes, Bryant. And it says that his cell location is 7404T.
Okay, I'll try to go get him.
Okay. Mr. Mosley.
How you doing today, sir?
I'm doing well. Oh, okay. Thank you, Miss Adamson. We may end up using the chat function for Mr. Bryant if we can. Mr. Mosley, sir, you were charged with being a fugitive from justice. And what that simply means is that there is a warrant for your arrest out of another state. And in this instance, there is a warrant for your arrest out of Broward County Sheriff's Department in Fort Lauderdale, Florida, for a charge of robbery. And they indicated they will extradite. So you have all of the rights and privileges that I discussed earlier. And in this situation, you have a right to challenge whether this warrant is valid or whether you're the right person that's named in the warrant. So it's generally called a writ of habeas corpus. And what happens is that if you tell me you want to challenge this extradition sometime within the next 90 days, there will be a hearing before a judge in magistrate court, and that judge will determine whether you are the person named in the warrant and whether these charges actually exist. They will not determine whether you're guilty or innocent. If at the end of that hearing, the judge makes that determination that you are the person named in the warrant and that the charges do exist, the judge will sign off on the governor's writ to have you sent back to Florida. From that day, Florida will have 30 days to come and get you. They can request an additional 30 days, up to a total of 60 days. So at the end of that period, if they have not come and gotten you, you'll be released out of the front door, but the warrant will not go away. So you can encounter a law enforcement officer 5 minutes after you walk out the door. They run your information and this process starts all over again. You can waive that hearing if you believe that you are the person named in the warrant. And if you have reason to believe that this warrant does exist, you can waive that hearing today, and the clock will start to run today on that 30-day up to 60-day period. Are you with me?
Yes, sir.
Do you have any questions so far?
No, sir.
Okay. So if you sign a waiver today and they don't come and get you, as I described earlier, again, you will be released out of the front door, but it doesn't mean that the warrant goes away. So have you had an opportunity to think about whether you want to have the hearing or waive the hearing?
I don't want the hearing. I know it was my girl, you know what I'm saying? She had got upset with me, and, you know, she thought I took something from her, and she called the police, and,
okay.
You know, they got to go through the procedures, and they charged me with robbery. I didn't know.
Okay.
I didn't know, you know what I'm saying? And I was moved to Georgia way before. I moved to Georgia in April. I went back to visit her. Me and her got into it, and I came back, and I guess she called the police. Yeah, you know what I'm saying, took something from her. But the thing that she said I took from her, that she had got it back. She found me.
Okay. Now, Mr. Mosley, you may want to consider hiring a lawyer in Fort Lauderdale to handle this sooner rather than later. Because we have instances where they've hired a lawyer and the lawyer is able to negotiate a bond. Had one guy from Tampa where the judge signed an OR bond out of Tampa. So the sheriff's department here, unless there are charges pending against you, has no interest in whether you are released on bond or you're held here until Florida comes and gets you. So you may want to consider that as a way that you can possibly deal with this faster. Okay? All right. So they're going to give you waiver forms to sign. And once you sign those waiver forms, you'll be free to go back.
So I waived the right to have the 90-day hearing, right?
Yes, sir.
Yeah. So as of the day, they got 30 days.
Yes, sir.
Because I had got in contact with my family, and my family got in contact with my girl, and she was saying that she was going to go to the court and try to clear everything up.
Well, I mean,
she didn't know that they charged me with robbery or whatever. Because when she called the police, she wanted her things back, and she got her things back, and she didn't know they charged me with robbery. Because when I called her and talked to her, she asked me what I'm doing in jail, and I was like, you know what I'm saying, something about Broward County charging me with robbery. And I told her she got to go get it taken care of, but she didn't know.
Well, Mr. Mosley, once you call the police, you bring a third party into it, and they get to make their own decisions.
Yes, sir.
So, do they have the waiver forms there for you?
Yes, I got the forms.
Okay, go ahead and sign those waiver forms, and then you'll be free to go back.
All right, sir.
Thank you, Your Honor. I believe Deputy McKenna is still trying to track down the other fugitive, sir.
Okay, and my understanding is that Mr. Bryan is hearing impaired. So I'm going to try to communicate with him using the chat function.
Yes, sir.
Because he's going to need a sign language. If I can't communicate with him, he's going to need a sign language interpreter. And I was not apprised of that. So I would have to continue his case over until tomorrow or Wednesday in order to have that to happen.
Yes, sir. I will call him on the radio to see if he's got him yet.
Okay.
One moment, Your Honor. Your Honor, Deputy McKenna has found Mr. Bryan right now. So they'll be here shortly, sir.
Okay, thank you.
Yes, sir.
Your Honor, Mr. Bryan is present now.
Okay. Bring him up. I'm gonna try to communicate with him using the chat function.
This is Mr. Bryan.
Okay, give me 1 second.
Yes, sir.
He tight. He's tight.
Okay.
Yes, sir.
You can speak. He can hear you. You can speak. You can speak.
Hold on.
Percy, hold on.
I'm typing the whole thing out for him. Okay. Deputies, do you guys have a phone that will allow a hearing impaired person to make a call, correct?
Yes, Your Honor. I believe that's in intake.
Okay. Let me clear up as to whether he wants to waive this hearing or not. He said that he contacted his lawyer. He has a lawyer in Texas, Doug Evans, and he contacted the lawyer over the weekend, but he hasn't heard from him. He said that he's here on a failure to appear, or the warrant is a failure to appear out of Texas, but he was, I think, in custody. And under that scenario, there is a good chance that his lawyer probably can get the warrant withdrawn. But again, that's based upon the representation that I've been told. let me clear up as to whether he wants to waive or not. And if he wants to waive, do you have the paperwork there?
I'm telling that I missed the court date from the test and what I was in the consideration, but it was just a small case. For the forgery check, just a small one, it was 2,000. And that's how much it is. I had to pay because I missed my court date. That's why the order was made back to 31st. So, my lawyer knew
he had the waiver here.
the waiver, what's the waiver there?
Read that.
Okay. The waiver, how long would I have to be sitting there?
Okay.
I can read that.
They want us to relieve time, they get the paperwork, and then we send it to her, and that way he can remove the water off her. You know, that's all he needs. So I don't want to be wasting time to be sitting there and say, well, why you got to request for hearing? So it's already known. It's already known.
Your Honor, would he need did he by any chance sign the waiver yesterday or?
He did not, at least from what I got. Let me take a look at it again. No, I have blank waivers. I can send them to you, Deputy Requena.
Yes, sir.
I'm gonna send that to you right now, and then I'll just let you get them and provide them to him to sign, and when they get back to me, I'll sign them.
Yes, sir.
But I believe, based upon what he said about the failure to appear, now I'm not a judge in Texas, so I can't vouch for this, but it could be something as simple as his lawyer notifying the court as to what happened.
You just need that paperwork.
Yeah.
So,
because I can't imagine that they would want to spend the money to come up here on a failure to appear when he was in custody.
That's correct.
You know what? All right, I'm about to scan these in and I'm gonna email them to you right now. And then, yes, sir. Yes.
No, sir.
Okay. Let me see.
No, sir. My ears. So that's where they form on this out here. It's messed up the bed where it's at. All right.
We're almost done.
Okay.
Okay. I'm scanning these in now and I'm gonna email them to you, and he'll be free to go back. And just please just inquire into that phone situation so that we can hopefully get him moved on.
Okay, will do.
Okay, thank you.
All right, you're welcome. All right. How long want to have